with your last kindly. Serial number 13 and 44, Lord.
Yes.
13 and 44. It is connected to batch matters which are posted on 27th February 2000.
27.
The interim order may kindly be extended.
Post interim order to be extended. 13 and 44.
44.
13.
13 and 44.
427 interim order shall continue.
With your lordship and permission. Two contempt proceedings for admission, my lord. One is, my lord, regarding payment of salary. After reinstatement, direction has been issued to payment of salary. The same was not paid.
19th March.
Please.
Your Lordship, there is extreme urgency on health grounds, Your Lordship. Extreme urgency on health grounds. The patient is not responding to the treatment because of the family stress that he is facing due to contempt issues. So I have, earlier I had made out an urgency, 3rd February date was given. However, there was no sitting, so it has gone to 5th March. I have filed an application for early hearing. So it may be taken up on Tuesday, Your Lordship, on 12th.
PI.
It is not a PIL, it is a contempt matter. Yes. May it be taken on 12th. I have
Date is given.
5th March is given. All the dates, all the cases were given 5th March. I had filed application for early hearing. Copy is also served on the other side.
This is for posting of early hearing.
No, early hearing application I have given. This is for posting, Your Lordship.
What is that application? Post that application.
Application is already filed.
Then it will be posted.
There is extreme urgency, that is.
Application will be posted tomorrow. Not the matter. Application for prepone.
My lord, my lords, writ appeal, my lords. This is a fresh,
Lordship, serial number 51,
my lords, memo, my lords.
list number 1. I'm appearing for the accused in this matter. 2 weeks' time may kindly be given to file the reply and also objections to IA number 1 of 24, Your Lordship.
Serial number 36, my lord. Tenure is not inconvenient.
Serial number
36.
24th March. As requested on behalf of the investigation. Yes. ma'am.
My lord, serial number 32. A week's time, my lord. Senior is not well.
Why?
Ah,
Why?
He's admitted to the hospital due to viral fever.
Pardon? What is the reason for asking for attendance?
Anytime in next week, my lord.
Why you are asking for it?
Reason.
Why you are asking for
He's
time?
not well.
Who? Counsel. 3rd March.
My lords, this is a writ appeal matter, my lords, fresh matter. In contempt, we have been directed to initiate writ appeal within 2 weeks and take stay against writ.
25th March.
2 weeks will be,
Mention that contempt is going.
24th March is the contempt last date it has been issued.
Maybe. Yes.
Serial number 31, Your Lordship. It was posted for objections for impleading application. Today only we have filed the objections.
30, 31.
31, Your Lordship.
So what do you want?
No, we pray that objections may be placed before this court after that hearing may happen. We have filed it today only, so pray for time so that the objections can come before this court.
2 weeks time is granted to remove the office.
Much obliged.
Hearing the petitioner in serial number 96, Your Lordship.
96.
230 matter. I appear for the petitioner. Week's time may be granted, Your Lordship. Senior is having some inconvenience, she is unwell. So any date,
4th March.
oblige.
Serial number 18. I seek for a short accommodation.
Yes, madam.
Serial number 30. For petitioner, serial number 9.
Serial number?
30.
4.
30. 30. Serial number 30. 1 week time.
Which serial number? 30. So what is the request?
1 week time.
It will go to March 26 as requested on behalf of the petitioner.
My lords, serial number
As
33,
prayed for by
33, 42 and 45, my lords.
13,
33, 42 and 45, IV.
33, 42 and 45.
This time may be granted, my lords.
It will go to March, 20th March.
Please, my lord.
Serial number 92, my lords.
43, 42, and 45.
Five.
So all at the request of learned 14th, or 20th March.
Ship serial number 18. for a
Serial
short
number 92,
accommodation.
my lord.
Serial number 18, preparing for the appellant. For a short accommodation may be taken up next week itself.
There is a delay of 79 days. Notice is issued.
Check.
In delay application, notice is issued or not?
It's
All right, you don't know, 7th April, as requested.
My lord,
Yes, Mr.
That's one mention for listing, my lords. That's NGT, my lords, without hearing the board, has passed the order. That it's covered by my lord's judgment saying that, an opportunity must be given. That's they've given us a direction that, my lords, we have to be inspecting and complying with certain directions given by NGT within a week. That would be coming into this by Thursday. It would come in, that 1 week time period would get over, my lords. May I seek for listing either on Wednesday or Thursday, subject to my lord's convenience. I understand, my lords.
Wednesday.
Please.
Wednesday.
my lord, serial number 69, my lord. 69, it is a no confidential motion. Actually, today 11 o'clock is the meeting, special meeting is fixed. Here is what has happened, my lord, the SC/ST candidate being the president. He's given the resignation under the threat and force and against the members. That the inquiry has not been conducted. And by the assistant commissioner as well as the first, single judge. My lord,
So what
We-
do you want?
11 o'clock, my lord, what is happened is, the special meeting is fixed 11 o'clock. So ideally, because the president he has given resignation with threat. Inquiry has not been conducted, section 48(1) of Panchayat Raj Act.
We do not know what do you want ultimately. Don't argue the matter in mention. What do you want?
My lord, I request you, lord, to take the matter because 11 o'clock is they have fixed the meeting for no confidence by the assistant commissioner.
Huh.
Today is the 11 o'clock is there, my lord, is serial number 69.
We'll take up.
Uh,
We'll take up at 11 o'clock. It is in the office objection.
That I'll comply, my lord.
No. We comply with
my-
tomorrow.
I served the copy to the other side
We do
also.
not know. Unless office hours removed, we will not take.
I'll comply, my lord, because today is the.
We can't help. Tomorrow, by tomorrow, office hours will be, in view of the urgency pressed, the office, though, in view of the urgency place, this is listed under office objection. Is it? Serial number 69.
Please. I'll comply the office objection in the meantime. my lord.
Office objections are not complied with, which are as many as 10 in number. Learned advocate presses for urgency. However, since the office objections have to be complied with, let the appeal be posted on 11th of February. The office objection will be complied with before posting of the matter.
Copy is not served on the government also.
Copy.
I served the copy.
There's no reflection.
I served.
Yes.
Any other mention through which is
Till then, interim order will. Then, my lord, I'll comply the office objection till then, interim orders to me. I press the interim order, my lord.
It can't be passed like that. If you don't
Purpose will not be served because the.
no, it is your business, yes.
So contempt matter, still number 1.
They have filed earlier, remove the office objection.
No, the very next day only, last day only, I received the
Remove
copy.
the office objection.
Oh,
It is not minor objection. 10 objections are.
that is minor, my lord, I learned.
We'll set aside if you are right.
Please.
Mandatory, yes, whatever.
Still number 1. So contempt matters, Murthy K.
For the complaint, kindly 1 week time may be granted. Kindly 1 week time, my lord.
No, why?
My senior is out of place.
Senior is not there. 4th of March.
Name, please. Still number 2. So Mallikarjun Ji.
Notice returnable on 18th March.
Please,
Next also same.
same.
Still number 4. Mr. Sanchan.
Lord, the petitioner, my lord, had given application under section 79A.
Notice
yeah.
returnable on 19th March.
Published.
Seal number 5. Shashikant MP. Seal number 5.
Similar matter already disposed of, your lordship, then direction is given to.
Lords, this is in the process of being implemented, my lords. Some time may be granted.
Your lordship, in this matter already disposed of in connected matter. And direction is given to. Manager H is the single bench order, your lordship.
How come the same subjects are there?
Your lordship, subject is different, your lordship.
No,
Chemistry, your lordship. The same connected matter in the writ petition, annexure H, your lordship. Writ petition 13967 of 2023 connected with 14016 of 2023. The two subject, your lordship, one is chemistry and one is lecture of chemistry and one is English, your lordship.
following are the directions. In order dated 15th January 2025, pass disposing of the contempt. While disposing of the writ petition.
Disposed of,
Report 234, page 98. When the petition came up for, when the present contempt petition came up for consideration, learned advocate for the complainant stated that identical, the same order was subject matter of contempt petition number 1232 of 2024, which arose from the connected petition, which was dealt with in the same order by learned single judge. However, in which this is chemistry.
chemistry, your lordship.
However, in that case, the subject involved was English. On the post of it, the lecturer was to be appointed. Full stop. Then paragraph 2 is order, miss. Same, 2, 3, 4, 5, same. I made correct, at this stage, learned additional government advocate, Srimati Pramodini Kishan stated that the directions are under compliance.
Alright.
Also, the said fact is taken note of, said submission is taken note of.
Seal number 6. P. Mahesh.
Notice returnable on 20th March.
Seal number 7.
Notice returnable on 20th March.
Seal number 8. The Janardhan G. Seal number 8. Janardhan.
11 PM and 11 PM.
The undertaking given to this court, Lord Annexure, and earlier contempt, but Annexure C. Miller. Para 5, page 21.
What they are doing? What they are doing?
Miller,
They are doing what?
and they are doing work, but I produce the photograph. Miller. Started once again. Miller. That's the reason I have a complaint lodged, and once again they're continuing with that. But it was ensured that
Notice returnable. 7th March.
Seal number 9.
For that.
Chandrasekhar.
Complainant, please, Milords. This is violation of the final order dated 7/11/2024, Annexure A, page 15, please, Milords. Lordship may kindly see page, in Annexure A, page 31. not to proceed with the construction, dispute between two neighbors. Page 31, please, my lords, operative portion. B,
So appeal is pending.
please, my,
Appeal is pending
both appeals are pending, my appeal and his appeal,
before commissioner.
before commissioner. Learned single judge has directed this particular accused not to proceed with the construction. Who was the petitioner in that case? That it may kindly see. Last line.
Notice returnable on 7th March. 7th March.
Great.
PL matter, seal number 10. Shetty Deepak.
Hearing for petitioner, my lordship. My lordship is not feeling well, my lordship. Senior is not feeling well, my lordship. He is not recovered. Kindly requesting for the date, my lordship.
In every PIL, senior is not feeling well.
He is suffering from fever, my lordship. He has not yet recovered.
Time is asked for in this petition repeatedly. It appears that the petition is no urgency or hurry. Full stop, stand over to 9th of April. Next.
Seal number 11.
Any interim order is operated? Let's. Keep it early.
No interim order, my lord.
No interim order.
My lord, there is allotment of houses 25th of January 2023. The allotment of houses is subject to final outcome of the petition.
Ma'am, for the fourth respondent, it's not. For the fourth respondent, it's not. While my objections not, but
Which matter? This one.
like previous matter,
Previous,
serial number 10.
previous matter is already adjourned.
That's what just heard that. Not the interim order, not which is granted. Not it pertains to allotment of houses as such. But there is no allotment of house, my lord, in this scheme. It is the sites, my lord, will be owned by the parties. It's only, my lord, funding.
On that day you tell.
Please, please.
This seal number 11.
That's serial number 11.
But
My lord,
11, I appear, my lords.
in this,
My lords, would your lordships kindly have a look at the order sheet? The matter pertains to constitution of the Civil Services Board pursuant to the directions of the Supreme Court in TSR Subramaniam in the year 2013. My lords, a committee was constituted. The cabinet, my lords, in its unofficial meeting would keep the decision in the taken by the cabinet in its official meeting in abeyance. That is in the year 2014. After that, my lords, your lordships, my lords, in a division bench of this High Court, my lord, was pleased to direct the state government to constitute, my lords, the CSB, the Civil Services Board. Till date, my lords, it is not constituted. My lords, your lordships, my lords, in the month of August, would your lordships kindly have a look at that order, my lords? Directed, my lords, the state government, my lords, to take a decision, my lords, to constitute the committee.
We'll show the progress on the next week.
My lords, may I make this request?
My
Lords,
lord,
on the last occasion, the Honorable
My lord,
Advocate
my lord, it's referred to the subcommittee. My lord may grant me 4 weeks' time, my lord, and I will make a submission, my lord, as to when it will be placed before the cabinet.
May I make this request?
Because we are seeking for information from other states also with
This might
regard
be
to
a
the.
major decision. They will take time. They are doing it.
My lords,
No, it is, we have done it. It is not that we are sitting quiet.
my lords, it was done, my lords, over a decade ago. And in the unofficial,
Now also they are doing.
no, my lord.
Yes, my lord, I have stated that in my statement of objections, paragraphs 16, 17 and 18.
Which
Now,
was,
the latest information I have received is we need some more time because we haven't received a Malad report with regard to its implementation from other states. We have received from about
May I
4 to
just-
5 states.
may I just, my lord, I'm not saying anything else. My lords, on the last date on 18/12/24, the learned Advocate General, my lords, who appeared before your lordships, my lords, made a statement that the cabinet session is in progress. Therefore, my lords, he would take instructions and place it before your lordships today and sought for 4 weeks' time. And therefore, my lords, it was adjourned to today. Your lordships, my lords, were pleased to direct the Advocate General to place the status report before your lordships. Now, my lords, again today a request is made without placing the status report that they need 4 more weeks' time. My lords, it is not about, my lords, a question of 4 weeks, but the question is, my lords, for over a decade, no progress is made. And on each occasion, my lord, they would say that they would file a status report, my lord, and no status report is filed till today. The winter session of the cabinet is over. They said that they will place it before your lordships. Even today, it is not placed.
My lord, on the last date of hearing, the learned advocate general submitted that for the decision, the matter is placed before the cabinet subcommittee and sought for some time.
That's right, my lord.
We
That's all that I'm
see
saying.
that we are in the process of, my lord, finalizing it, but considering that we haven't received information from other states regarding the implementation, we are seeking for some more
Let-
time.
Our court, our high court has directed them to constitute. So irrespective of what any other state would do, my lords, it is required to be constituted. In your lordship's order of August
There is
24.
a Supreme Court directive also.
Yes,
Yes,
yes.
August 24, my lords, your lordships have noted that the act of the state government is bordering contempt and that your lordships would not hesitate to initiate. I'm not, my lords, requesting for initiation of contempt. Ultimately, my lords, in the interest of public and the government servant.
So we have noted the Supreme Court order also in one of the earlier order.
Yes, my lords.
Yes,
Your
sir.
lordships, my lord, in the order of August 24, my lords.
August 20.
Yes, 20th of August 2024.
This is regarding security of tenure for,
Tenure and how the transfers and disciplinary.
once he is placed in a particular
Please,
post.
please. So grateful. Year 2021, my lord.
You don't have a policy like 3 years, they have to be in a place and things like that?
My lord, we'd like,
State government
no
has a-
policy as such is not, that is the reason why we are seeking for information from other states also, my lord, to see that.
Madam, it's an administrative function. In the interest of the general public and that the element of corruption is rooted out, there has to be a security of tenure for a civil servant unless there is really pressing and exceptional circumstances to be recorded in writing if he has to be disturbed. Everybody knows what is happening on the ground.
Not finally 4 weeks.
You
time.
don't require, this is not some rocket technology wherein you require information from other departments to see to it how you have to improve your rocket or some scientific thing.
Very well.
This is purely an administrative aspect in the interest of the state. You need not get information from other states for this particular purposes.
My lord, we didn't want to have a defective, my lord.
It can't be a defective thing, madam.
I'm sorry, I used the incorrect word. My lord, we didn't want to have an ineffective this thing. Now, since my lord has.
What is ineffective? If a person is posted to a particular place, unless he's retained there for at least say around 3 years,
My lord.
how can he deliver?
My lord is right, but my lord may grant me 4 weeks' time. I'm not asking for a long adjournment because the matter is in progress. And then, my lord, the learned advocate general will apprise my lord of what has happened after 4 weeks.
Learned additional government advocates, Matrimonial for 6 times, requesting the court to adjourn the proceedings for 4 weeks. Turned over to 5th of March.
My
5th
lord,
March.
4 weeks, my lord, I won't move for time.
Today is what? Today is 10.
10,
21st March.
obliged.
On that day, progress in the subject matter shall be The court shall be apprised of the progress
Yes, yes.
on the subject.
Great.
Obligement.
The Green bench matter, still number 12, to P. Mahesh.
Petitioner Lordship, seeking for writ of mandate.
My lord, I'll take notice.
Notice written ever now. 24th, 10th of March.
Right.
My Lordship, this matters, my Lordship, the law has been amended, my Lordship. They have to consider within 24 from the 24 months from the date of amendment, my Lordship. That going to lapse on 17th March, my Lordship.
7th March.
7th.
Obligement.
Notice already issued. Notice already issued.
Already has been issued, my Lordship. I served the copies also.
6th March.
6 March. 13 is urgent, still number 14. Kirti Krishnam Reddy.
I appear for the applicant.
Responded. May this submit something, but this was just challenging a grant of tender in the favor of the current private respondent. Now, what has happened was the tender has been served. And there's a fresh tender which has been called upon by the tender inviting authority. So the tender which was under challenge was awarded to me now, currently under the writ appeal. Not it has served its purpose. I don't know whether there might be an argument apart from that. A tender was called upon, it was awarded to me ultimately by the order of the learned single judge. Now the tender has been complied and it has been completely served. So the tender inviting authority, for the current financial year, has also invited a fresh tender. So possibly this.
Yes, but I must accede to this, that though the order of the learned single judge according to us was had some errors, but during the pendency of the appeal, I am told they have supplied the goods for which tender has been invited. But in public interest notes, I may not have to press this appeal for that reason. Lordship may keeping open the questions decided by the learned single judge, dispose of the appeal. Keeping open the questions which has been decided.
It was stated where both the sides jointly that the subject matter is issues. The appeal is accordingly disposed of. Or the questions of law are kept open to be hesitated and considered in the appropriate case.
Great.
Still number 15. The Pradeep Yasokar.
Lord, 15, my Lord, may I seek for a short passover, Lord.
Passover is not.
Four matters, lots, which are WA 974 of 2024 and writ appeal 1003 of 2024, my lords. If all the three matters are connected and heard together, my lords, I think it's listed in the March, my lords.
Lord, there is an application for stay that I have filed, my Lord, independent.
12th March.
March.
Grateful.
Grateful.
11th.
Number 16. Hegde Ramchandran.
I appear for a first respondent. I will have to file my objection. I appear for a first respondent.
Learned advocate Mr. So appears and wants time to file Wakalat Nama stand over to 24th March.
My Lord, I'm appearing for respondent number 4, my Lord. In this case, voluntarily I have filed Wakalat, my Lord, for respondent number 4. Kindly direct to the appellant to serve the copy to the.
I will serve a copy. I will serve. With the lordship kindly. I prayed for stay. There is a contempt petition filed.
No, contempt will come before us only. Yes.
This is number 17. The state appeal.
Yeah, my lord. State appeal, my lord. There's a delay, my lord, in the appeal.
So notice held to.
I'll take out.
Notice returnable on 7th April.
My lord, appear for. I can serve a copy on it, my lord.
Appear for complaint in connected.
Connected contempt, I'll serve a copy.
Or that will also go to 7th April. Next.
18 is urgent, still number 19.
This is a case where
The suspension order has been passed by the board, which is an appellate authority. Under the C&R rules, disciplinary authority is the managing director. The appellate authority is the managing director and the two directors. Now the board has passed an order. Sound. But along with the memo, rules have been placed on record.
Yes.
Yes, what is the problem?
Well, at page 164 is the proceedings of the board, Millets, where an order of suspension has been passed and the MD was directed to implement it. Under the rules, C&R rules, the suspension can only by disciplinary authority or by appointing authority. It is the managing director is the disciplinary authority. And appellate authority is the MD plus two directors. I placed on record the rules, Millard, along with the memo. The last page of the memo.
What was the interim order granted, which is okay, vacated?
Stay of suspension was
Stay of
granted,
suspension.
so that the application can be forwarded where I was eligible to the post of the managing director.
So go to the single, judge. Is pending. Petition
What?
is pending. Petition is pending.
But your last may direct the learned single judge to take up the matter immediately because I was eligible for MD. And if an order of suspension is stayed, my application can be processed. Now that came in the way now. It is a case where an authority who has no jurisdiction to pass an order of suspension, it is order passed by the appellate authority. It is covered by the Supreme Court judgment. Order code. Page 16, I have extracted the decision. Ninety. May I take your lordship's page 16 of the appeal memo? That is a judgment of Justice Sawant J. Para 5.3. Surjit Ghosh versus UCB 95 to SCC 474. It is true that when an authority higher than the disciplinary authority itself imposes a punishment, the order of punishment suffers from no illegality when no appeal is provided to such authority. However, when an appeal is provided to the higher authority concerned against the order of the disciplinary authority or a lower authority, and the higher authority passes an order of punishment, the employee concerned is deprived of the remedy of appeal. It is a substantive right given to him by the rules regulation. An employee cannot be deprived of such substantive right. But the interim order which is vacated may be continued for a period of 2 weeks. and the matter may be directed to be listed for final hearing.
So heard learned senior counsel, Mr. So-and-so for the appellant, assisted by learned advocate, Mr. So-and-so. Then note the appearance of all. You are appearing?
Please, 1 and 4, 3.
So first will be the name of.
1 and 4, I'm
Shanti.
sorry.
We have 1, 2, and 3. 1 and
4, Malord.
1 and 4. The present appeal seeks to challenge order dated 4/12/24 passed in the pending writ petition number, pending proceedings of writ petition number 3159 and 2024. On a single judge thereby vacated the order dated 26/11/24 whereby the suspension against the petitioner was stayed. Full stop. In the writ petition, two main prayers were made. First was to set aside the show cause notice dated 9/9/24 issued in respect of certain irregularities alleged against the petitioner. And the other challenge was to order of suspension dated 21/11/24 which was passed against the petitioner appellant in contemplation of the disciplinary inquiry. Full stop. While vacating the stay of suspension granted earlier from a learned single judge, rested his order on the following reasoning. Quote paragraph 27 on page 33. Full stop. There are two reasons why the court is not inclined to interfere with the interim order. Firstly, the aforesaid reasons supplied by learned single judge for vacating the stay of suspension could be said to be proper and legal. Secondly, the order by its very nature, an interim order, and it is passed at the interim stage when the main challenge in the writ petitions are pending for consideration on its merits. Full stop. Rights of the parties, rights of any of the parties are not finally crystallized. Even the legality of the suspension order has to be finally examined. Full stop. Paragraph. Not only that, learned single judge has observed to make it clear that, comma, extracting from paragraph 30, then inverted comma continuity, needless to state, comma, full stop. In the aforesaid, the court is not inclined to exercise the appellate jurisdiction when the appeal is pending at large before learned single judge. In the totality of facts and circumstances, comma, we open for the parties to request learned single judge for expeditious hearing and disposal of the writ petition, to which from a learned single judge will give a due regard, having regard to its his timetable. The petition is the appeal is disposed of accordingly without expressing anything on the merits of the subject.
Seal number 20. Ashwini.
This is the writ appeal, my lord, preferred by the university against the order of the learned single judge dated 8/11/2023, my lord. Whereas the finding was that in the result, the respondent university is directed to extend the monetary benefits that accrue to the petitioner. The result of review of promotions undertaken on 23/11/2013, whereby the petitioner was accorded promotion as assistant registrar with effect from 24/12/2009. The pensionary benefits shall also be refixed in accordance with the order. All monetary benefits shall be computed and made over to the petitioner within 3 months. So the contention of the university is, my lord, that as on date of retirement, currently the respondent has retired. And as on the date, he was not even born in this cadre of assistant registrar, my lord. And hence he cannot seek benefits of the cadre at all, as held by the Honorable Supreme Court, my lord, in the case of Uttaranchal Forest Rangers. As of the date of the retirement, my lord, he was not even born in the cadre of the assistant registrar. In fact, he retired as superintendent and from a retrospective date, my lord. But he's claimed benefits as assistant registrar currently.
This order is based on some earlier proceeding.
Yes, my lord. So there have been a series of judgments by this honorable court, my lord, based on which the seniority list has been revised from time to time. Now, after one such case, my lord, the respondent has given a letter saying, I have, please note that I'm reporting to duty as so-and-so post. Whereas he was not even entitled to that post as on that date.
Yes, what is?
Your Lordship may kindly take page 110. Seniority list in the cadre of assistant registrar prepared in accordance with the order dated 17/10/2012, Honorable High Court order so and so. Your Lordship may kindly take serial number 15. The respondent herein, his cadre is shown as 24/12/2009, date of promotion as assistant registrar. The next document, Your Lordship, page number 112. Reporting to duty as assistant registrar with effect from 24/12/2009. He has reported to duty. 2014, he has retired. Now, Your Lordship may kindly see, my learned friend is talking about a seniority list 23/11/2013, which was called in question before the Honorable Single Judge. The judgment is at page 131, starting at page 120. Lordship may kindly turn to page 120. 131, Your Lordship may kindly see. These writ petitions were filed under Article so and so, praying to set aside the final seniority list dated 25/10/2013 of officials and so. That was the seniority list which was under challenge. Your Lordship may kindly take page 153. The last portion of that paragraph 26. It is a general observation with regard to consideration of objections to the provisional seniority list, and therefore the relief sought for in this regard to recall the order dated 17/10/2012, fast and writ petition so and so is misconceived. As a consequence of the aforesaid discussion, question of quashing the final seniority list dated 25/10/2013 is not called for. That seniority list has become final. And that seniority list anyway came into existence after the first two orders that after the respondent has taken charge as assistant registrar. All this was brought to the notice of the learned single judge. In fact, on an earlier occasion, the petitioner was before this honorable court. Your Lordship may kindly see page 44. Page 44. The petitioner is at serial number 5. Lordship may kindly see at page 55, paragraph 8 onwards. I will not talk about the reply. I will go straight to the finding, Your Lordship. Page 57. Accordingly, the writ petitions are allowed. Annexure N is hereby quashed. That was an endorsement given to the petitioner that was under challenge. The respondent is directed to recast the seniority, keeping in view Annexure B, B1 and C insofar as the petitioners are concerned, taking into account their date of promotion as 30/11/1981 for the purpose of seniority and for the purpose of notional monetary benefits, which they would be entitled to. The petitioner may not be the respondent may not disturb the ranking of the petitioner, the respondent so and so. This was taken up in appeal, Your Lordship. The appeal was rejected. The writ appeal 5181 of 2009 filed by the university was rejected. So therefore, their appointment order and promotion was fixed at 30/11/2018. That is at Annexure B, page 28, Annexure B to the writ petition. And thereafter, he was promoted as assistant registrar, retired, took charge as assistant registrar, retired as assistant registrar. Now he is not being paid his pensionary benefits, and therefore the learned single judge has observed that he has been in litigation forever. When all the orders are very clearly in his favor, that is pensionary benefits we refixed and accordingly released as per the.
What is your ground?
Our ground is that, my lord, this is a judgment I wish to place on record, my lord. As per this judgment of the Honorable Supreme Court, my lord, an employee cannot claim benefits of a cadre he was not even born into, my lord. Para 37 of this judgment may kindly be read, my lord. Page 364. We are of the view that no retrospective promotion or seniority can be granted from a date when an employee has not even been born in the cadre, so as to adversely affect the direct recruits appointed validly in the meantime, as decided by this court in Keshav Chandra Joshi versus Union of India, held that when promotion is outside.
Better give synopsis, both of them.
Please, Your Lordship.
Please.
Give short synopsis.
I have prepared my synopsis, Your Lordship.
I will place the synopsis on record, my lord.
24th March.
Obliged.
Still number 21. Adinaranappa.
Challenging the ex parte passed by the single judge. The appellant is an highest bidder in the tender. You kindly single quote in charge right. Ex parte order passed against this respondent had been challenged.
May I make a submission, my lord?
For R1, please.
My lord, I am for all three, my lord. My lord, he has filed the wakalat in writ petition, so the appellant has filed the wakalat. I'm passing the daily order sheet of the writ petition.
No. The thing is, a wakalat was filed in the writ petition on behalf of the appellant. They did not address the argument at all. They did not appear. Therefore, court said that you have been placed.
My lord, he has refused to receive the summons issued by, notice issued by the honorable court. And after he has come before the court and filed the wakalat, for that the learned single judge has, to accept the notice, they have imposed the fine of 5,000 rupees. He did not pay that. Hence, he has placed ex parte, my lord.
That's it, one submission.
I'll pass the daily order sheet of the writ petition, my lord.
One submission, please, my lord.
So you are given
Who
are you?
Initially, the second respondent constructed the public toilet and it was called for.
You are second respondent.
Mele.
You are respondent 3.
In the writ, he is R3, please.
Who are you?
I am a action purchase tender. I am a highest bidder in the tender. I was participated. The second respondent called for tender in respect of the public toilets. I got participated and I am the highest bidder in the tender. As per the norms of the tender, they executed the lease deed in favor of the appellant. He is in the possession of the property as per the terms and conditions. I have produced all the document to show that I am in the possession of the premises. Along with my application, I have produced all the documents.
Court officer.
It could, it could.
Lordship may kindly see the conduct of the appellant before the
And
learned
13/12/2013.
learned single judge.
Page number 2, my lord. Order dated 13/12/2023, my lord. Notice issued to respondent number 3 has been returned with the endorsement refused. However, Shri Manoj SN Learned Counsel submits that he has filed the wakalat for respondent number 3. It is impossible to anyone to refuse the summons issued by the court. In that view, the matter is, in order to accept the wakalat number, respondent number 3 is directed to make a payment of 5,000 rupees payable to the advocate's clerk's benevolent fund. So, which shall be done within 10 days from today. And the next order date is 20/12/2023, my lord. None appears for the respondent number 3 and cost is also not paid. Unless cost is paid, respondent number 3 will not have no right to argue the matter. 27/3/24, my lord, page number 1. On 13/12/2023, this honorable court has accepted the wakalatnama filed by the Manoj SN for third respondent subject to payment of cost of rupees 5,000. This court has called upon the third respondent to pay the cost, observing that after refusing the service of notice from the court, he has engaged the service of the Shri Manoj SN and this conduct would be impermissible. As per the office note, the cost is not paid. Shri Manoj SN remained absent. It would be therefore appropriate to discharge the wakalatnama of Manoj SN subject to the further orders and place the third respondent as an ex parte in order to.
Okay, have you paid the cost?
Till date,
I have paid to my advocate, but he is deposited or not. Once we.
That is not a concern. Have you paid to the court? You initiate separate proceedings against your advocate.
Because once we engage the advocate, we thought that he is look after the matters.
The same,
But
understand you are blaming
no.
brother advocate. No, you personally are blaming a brother advocate. Tomorrow the same thing may befall on you.
In the normal course of conduct, every client do the same to the, once the wakalat is handed over, whatever the
Well, have you
instructions
paid the
given.
cost or not?
As per my instruction, he paid to his.
You are not paid as per the court orders.
As per the court order, I had entrusted the money to the council, but he is deposited or not.
Lords, my lords, the crux of the matter is
You pay the cost as ordered, then we will hear you.
Obliged. I will deposit whatever the cost imposed by this court.
learned advocate to the
I may be permitted to file detailed objections to this.
The
bill.
cost of 5,000, as directed by the court in order dated 27/3/24. Extend or to 5th March, before which date the court shall be deposited. Cost shall be deposited.
Obliged.
Obliged.
Still number 22. Shubha.
I appear for the appellants, my lord.
Correspond in this case.
My lord. This matter pertains to granting of compensation for usage of lands, my lord. The appellant corporation has installed a tower and drawn 66 kV electric line, my lord. For that, an amount of rupees 1,07,500 was paid towards the land usage and 6,48,249 was paid towards the trees, my lord. Overall, amount of rupees 7,55,749 was paid to the respondent, my lord. Unhappy with this compensation, The respondent approached the district court for enhancement of compensation, my lord. The learned trial judge again has reassessed the values of all the plants and the land and has enhanced the compensation by 7,92,764, my lord. This amounts to double compensation, my lord. Against this order, we approached the learned single judge. The learned single judge refused to interfere with any of the order of the learned trial court, but only accepted our contention that no deduction was given to the amount already paid, my lord. Hence, we are before this court. The learned trial judge, my lord will find it at page number 40. Page number 40, my lord. Based on grant of compensation in some other case, not even referring to that, has again fixed compensation and taken 54,500 per gunta, my lord. Here, my lord, the corporation has granted compensation based on the competent authority, who is the district commissioner, my lord. He is the person who, according to the guidelines and the directions fixed by the Union of India Power Corp, Ministry of Power, has fixed the compensation, my lord. 2 lakh per acre, which comes to 5,000 per gunta, my lord. The Ministry of Corporation has also directed for a certain amount to be given as compensation for fixation of tower, my lord. Accordingly, rupees 85,000 has been fixed for installation of tower, my lord. The learned trial judge does not take into consideration any of these facts and again fixes the compensation, reassessing the same, taking 54,500 per gunta based on some other land, my lord. The relevant portion is at paragraph number 20, my lord.
Yes.
My lord, the lands are the fertile lands, my lord. It is in Gubbi Taluk. My lord, the lands are the garden lands. In view of the installation of the electrical lines, my lord, it cannot be, the entire area is made for growing of plantation crops. My lord, by considering all the relevant aspects, the reference court has enhanced the compensation. My lord, learned single judge has considered all aspects and has given an option to deduct the compensation already paid at page number 19, my lord. Para number 8. His grievance has been considered and learned single judge has given an option to deduct the compensation already paid to the claimants and to only small enhanced compensation the landowner will get, my lord, if the order of the reference court is implemented.
The order at page 30, judgment at page 30 of the district judge.
Please, my lord.
Guru must be in telegraph.
Telegraph.
Why should we read it?
My lord, there are number of petitions. My lord, my only trees and all I will not stress, my lord. The only contention for argument is we have already paid compensation towards diminution of land, my lords. Again, based, if my lord comes to paragraph number 20, there is relevant portion is there, my lord.
20 of?
My lord, running page number 40, page number 20, running page number 40, my lord. This is the order of the learned trial judge, my lord. Therefore, first line, my lord, first line. Therefore, though both the lands are situated within the jurisdiction of Gubbi Taluk, Tumkur district, the said lands are situated at different hoblis, and therefore the judgment in RA number 132 of 2021 relied by the petitioner is not applicable to the case.
Where are you reading?
Pages are not matching.
My lord, next pages, my lord, 40. Running page number 21, my lord.
20.
21, internal page number 21 of the
Correct.
judgment. I'm sorry, my lord.
Here the petitioner sought compensation.
Internal page 21 of the learned trial
21.
judge. Civil miscellaneous number 392 of 2020.
Correct. Therefore, though both.
Therefore, though both the lands are situated within the jurisdiction of Gubbi Taluk, Tumkur district, the said lands are situated at different hoblis, and therefore the judgment in RA number 132 of 2021 relied by the petitioner is not applicable to the case on hand. This one, the learned trial judge does not accept. But further, my lord, however, this court In similar miscellaneous petition in which the respondent has drawn the high tension 66 kV electric transmission line, the property value of the land is assessed at rupees 54,500 per gunta. In order to maintain the uniformity in assessing the diminution of land value, this court deems that justice would met if the amount of rupees 54,500 per gunta is considered in this case also. This case also. My lord, there is no proper reasoning also, my lord. There is no case number also given. Whether that order is has reached finality is also not forthcoming, my lord. Just because in another case 54,500 per gunta is taken, the learned trial judge goes to accept the same in this case also, my lord, which is erroneous. And already as submitted, my lord, we have already paid compensation towards diminution of land and also for installation of tower, my lord. Hence, reassessing amounts to double compensation, my lord, which is not.
Now, do you dispute that 54,500 rupees?
Yes, my lord, 54,500.
Now, we are required to provide that case law and say that that is
Yes,
not
my
what.
lord. We had produced before the learned trial judge, we have produced all the exhibits, and as per the direction and guidelines issued by the Ministry of Power, the DC is the competent authority who will fix the land value based on the other circumstances, my lord. If my lords look at the exhibits, we have already furnished, my lord.
No, you have to show in similar civil miscellaneous petitions, it was not taken at 54,500. It was at some other value. Then we can interfere, not otherwise.
My lord, my submission is all the cases where 54,500 is taken, we have challenged and we have succeeded in all the writ petitions, my lord. Around 1,500 writ petitions, we have succeeded. Only this writ petition, because it came before a different bench, it's not accepted, my lord. Otherwise, I'm sorry, my lord.
Have that reached finality?
Yes, my lord, it has reached finality.
Show that to us.
Yes, my lord, I will produce, my lord. And my lord, even the learned trial judge does not take into consideration this aspect at all. No discussion is made, my lord.
This she says in similarly situated matters, the court judgments of that has been altered subsequently in right petitions.
Which are those petitions?
I will produce, my lord. There are around 150 writ petitions has been allowed, my lord. From past 4 years, all the writ petitions has been allowed. Only this writ petition.
So that all.
Yes, my lord. It may be.
When?
I will produce the numbers, my lord. Any 15 days, 2 weeks time may be granted, my lord.
11th March.
Much obliged.
Number 23. NC Basurat.
The appellant was a driver. On account of the accident, Malad was accommodated light work. And instead of protecting the pay scale of the appellant, his pay has been reduced to office assistant grade A. As per the provisions of the rights of persons with disability, the respondents have to protect the pay scale of the appellant. But instead of maintaining the same, his cadre itself was changed to the office assistant grade A. Then he made a representation. But the second respondent has rejected his request by issuing the endorsement. Endorsement at annexure H. Then the same has been questioned before the learned single judge. The learned single judge held that there is a delay of 13 years in questioning the same has rejected my writ petition. Annexure C is the office order issued by the second respondent, wherein he was accommodated light work from 2010 onwards. And instead of protecting his pay scale, my lord, his cadre itself was changed to the post of office assistant grade game.
So you are questioning after 19 years.
No, my lord. My lord, as per the provisions of rights of persons with disability,
Pardon?
section 20 of 20 class 4, my lord.
20 of
Class 4. Non-discrimination of employment. No government establishment shall discriminate against any person with a disability in any matter relating to employment. No government establishment shall dispense with or reduce in rank an employee who acquires a disability during his or service or her service. My lord, annexure C is the order.
notice written over.
Well, the disability is defined, my lord, and he has to have disability of 40%. In this case, kindly see page
Consider
23, my lord.
6th of August, 6th of March.
Number 24.
Appear for the appellant. But may I request for a short accommodation in this matter? There are some, please.
What is the subject matter?
No, subject matter is the first respondent had sought inclusion of her name in the record of rights.
Not in the record of rights, my lord, in the e-Kata. Her name was always there. We wanted it in the e-Kata. They, my lord, said, my lord, produce one fabricated Xerox copy. When the original was summoned, original, my lord, had my father's name, and my lord, thereafter, my lord, after his death, my lord, my name has come. Original grant certificate. They, my lord, produce a Xerox, and then, my lord, all that is, my lord, recorded by the learned judge.
Computerized record of rights.
RTC.
So then
The
e-Kata-
RTC, that was the request, that her name was being reflected in the manual RTC. And when the records were computerized, the petitioner's name was not included in those RTCs.
E-Kata is consequential.
It's a consequential, my lord, which takes place. What has happened, my lord, in this case, there are issue register which were produced before the learned single judge, my lord. The learned single judge on 24th of January 24, my lord, seeks for FSL report that the original records have to now be sent to the forensic laboratory for examination. Because the earlier, the name of the petitioner's father was not shown in our records. One record shows
Who prompted this exercise?
the learned single judge.
No, the exercise of sending it to FSL, etc.
FSL, my lord, the lady, my lord, because FSL, my lord, they asked.
Somebody disputed.
We disputed.
They, my lord, disputed the
state
original.
itself
He got now,
disputed.
thereafter, my lord, he got the original. When he saw the original, my lord, ultimately, my lord, FSL, what does it do? Look at the original. Your lordship, my lord, learned single judge, thereafter, my lord, got the original. And my lord, he saw the original, and when my lord, my lord, he found out that one original was already there, seized and kept in this honorable court. The other, my lord, issue register, my lord, he got summoned thereafter. Because they started saying issue register, there's something wrong.
No,
Anyway.
this requires a little more hearing, and I'll have to place those records before this court.
When you will argue?
May I request for 2 weeks' time, my lord? By then I will make my submissions. With regard to the, my lord, may I just pass on these two orders, which may require a consideration?
Thank you.
Lord, the order dated 24th of January 2024, last 3 paragraphs may be seen, my lord. Nevertheless, Lordship got it, my lord. Nevertheless, since a serious dispute is sought to be raised at the hands of the learned government advocate, that entry found in page number 63 of the original grant register, register of Darkhast for cultivation with regard to the last entry in the said page which reflects grant order number so-and-so in favor of Muni Kempanna, son of so-and-so, Shri so-and-so, both being granted 4 acres in survey number 28 of Katgenhalli village, this court deems it appropriate to direct forensic verification of the document.
Please look
At
at.
the same time, I'll just complete
Sorry,
this
sorry,
paragraph.
my apology, my
Sorry.
apology.
At
My-
the same time, expert's opinion may also be required about document in page number 63 of the scanned copies, reflecting the name of so-and-so. Experts have to say whether the original entry in the name of Munishamappa has been removed and thereafter was inserted in place of.
This is
So-
the same matter.
Same
Same
matter, my lord.
matter.
Please look at, my lord, the later order, correct, later order, 1, 2,
Now this,
first page itself. First page 1 itself, my lord. My learned friend read to your lordship, my lord, the order at dated 24/1. Please look at, my lord, the later order. 1, 2. On the previous occasion, this court directed the learned advocate to furnish the original issue register pertaining to the land in question. Accordingly, AG has furnished the original register in the year for the years 60 to 63, 64. Then, my lord, he looks into it and passes the appropriate order, my lord, impugned order, which is, I'll point out all that.
without waiting for the FSL order.
FSL order, my lord, when
FSL
the
order,
original
I'm
is before your
instructed-
lordship, that was before, my lord, the original was summoned. Anyway, my lord, we'll point out.
This may require a little examination on this because
Original was
Our
produced
case-
by them.
it's
Original,
produced
my
by
lord,
us.
what happened was, initially, my lord, they produced Xerox copy. Insert Muni Venkatappa, my lord, they insert, my lord, Muni Chamappa. When I summoned the original, Judge, my lord, was shocked to note that, my lord, Muni Venkatappa is my lord, has name of Muni Venkatappa is there in the original register. He seized it and kept it here. That was, my lord, not the issue register,
And the original was produced by the state.
later, original of Sagoli chit, issue register. That was, my lord, grant register. Grant register is one document. Issue Sagoli register is another document. Both have, my lord, Muni Venkatappa's name. Anyway, my lord, I'll point out all.
I'll place all this.
This might clinch.
Yes, my lord.
Last on.
I'll point out.
I'll
We'll
make
argue
my
it.
submissions on this.
We are not concluding. When do you want?
May I request for?
Then go to 11th March.
Yes, please.
Number 25, Mr. Narasimha Raju.
Item number 25, your lordships. I appear for the caveat respondent number 4, your lordships. Lordships, this matter needs to be connected with writ appeal 1814 of 2024, your lordships. In both the matters, there is a challenge to the same order passed by the learned single judge, your lordships.
When it is coming up?
It is
That
next
is on
coming on 21st February.
21/2, my lord.
21-2. Send over to 21-2 to be listed with. Writ appeal
Publish.
1814 of 24, which is stated to be connected.
Please.
Appeal arising out of same order.
Publish.
Number 26. Hanumantappa B. Ravigoda. Number 26.
And for the respondent number 5, my lords.
So nobody is there, then let it go to, it may be listed on 10th March.
Publish.
Number 27.
27, my lord, I am seeking a short accommodation, my lord, serial number 27. Pleadings are complete, my lord.
20th March.
Grateful.
Number 28.
For the petitioner, on the last date of hearing, your lordship said completed hearing this matter pertaining to encroachment of the road area, the respond number 9.
Argued, my lord, last
Sure.
occasion. That was senior counsel, Mr. Udayawalla, has argued this matter. This is a, my lord, case where, my lord, 1985, my lord, ground floor was constructed. And 2021, this PIL is filed saying that there is encroachment of the road. It was argued at length, my lord.
Please, my lords.
Argued with this bench.
Yes, my lords.
But actually it is posted for, my lord, the orders, that's how, my lord. After conclusion.
Wherein the dispute was with respect to width of the road, my lords, wherein all the government authorities have given a report stating that there is an encroachment.
He said that it was argued last time.
Please, my lords. It was completed, my lords. Your lordships had expressed that it would be posted for orders, passing orders.
When was the last date of posting?
21st May,
21st
21st of
January.
January, my lord, arguments were concluded. On that day it was there.
Let us see what is it.
Lord, the PIL is regarding construction of a building by respond number 9 by encroaching upon the road area.
Lord, if it is to be heard, my lord, again, Lord, I seek for a passover. Kolla is,
No, Passover will not be used. Let us see what.
Lord, if it is to be argued again.
Lord, if I may take your lordship's kind attention to the report filed pursuant to the directions of this honorable
We
court,
have
the
filed
report was
objection to
filed
that report. We have filed
stating
objection.
that there is an encroachment of the road area.
That photograph was there.
Please, my lords,
Yes, yes.
wherein the electric pole was coming in between. All the government authorities, even in their pleadings, have submitted, my lords, that,
Page 95.
please, my lords.
There is no obstruction to the road.
Lord, the government authorities have given a report stating that there is an encroachment.
My lord,
And
we
even
have
before
filed
this
detailed
honorable court-
objection to the report, my lord. The report was, my lord, filed and we filed objections. So what is the mistake committed by, my lord?
We'll recollect it.
Please.
We'll list it on 27th of February.
Please.
27th. Bless.
December 29.
Lords, I am for the petition in this case, Lords.
There is fourth response.
Point 1 to 3, my lord, I want to file objections. Points 1 to 3,
Want to file objections, all
3 weeks.
25th of March. In order to enable the respond number 3 to 5, to file is their objections. Great.
I may request the petitioner to serve a copy upon me that I.
Now copy
for the
to all the
possession
council.
control.
You want a copy?
Yes.
Yourself.
Yes.
Your copy is thrown those.
30 to 33 are urgent. Number 34.
Great.
To P. Rudrappa. 34.
My lord, this matter pertains to filling up of vacancies to the post of the president and members of the consumer forum, my lord. My lord, a committee has been constituted, my lord, headed by a judge of this honorable court. My lord, I had filed a memo along with a notification on 26th. My lord, for the post of the president, my lord, we had issued a notification on 30th December 2024, my lord, fixing 28 January 2025 as the last date for receipt of applications for the post of the president. My lord, we have received 6 applications.
Chairman of the commission,
My lord,
Chairman of Consumer Commission,
President.
President.
My lord, and the other vacancies also, if my lord could grant me 2 weeks' time, I will apprise my lord with regard to my lord filling
Lord.
up the post, because the last meeting.
My
was
lord, they
held
are
on
always
third-
saying like that, my lord, they are not filling up the vacancies. Keeping on saying the same thing, my lord, from 1 year, my lord. Lord, the president of the state commission has been retired, my lord, on May month of 2024, my lord. Even after lapse of 7 months, they have not filled up the important post, my lord, president post. And also, my lord, there is no quorum in the several district forums, my lord.
My lord, could I
Several
please
districts,
pass
not one
on
member.
the notification, my lord, the communication which I have received. Sir, please take a copy.
The petitioners by filing this public.
Your lordship may kindly see page number 26, my lord, annexure B. Uttar Pradesh High Court was pleased to pass the order, my lord, to continue the present members and president, my lord, until the new appointment is made, my lord. On the basis of the Supreme Court judgment, my lord, interim order has been passed by the Uttar Pradesh High Court, my lord. The lordship may kindly see annexure B, page number 26.
My lord, the committee is in place now, and the committee is in the process, my lord. A communication that was sent to me. May I please submit this to my lord to peruse?
Desperate to direct the respondents to fill up all the vacancies of presidents and members of the consumer forums, including the State Consumer Disputes Redressal Commission in the state of Karnataka. Post of pursuant to notice issued in the petition from a learned additional government advocate, Srimati Nilofar Akbar, appeared to the respondents and filed a memo dated 26/8/24. Post of paragraph in the memo, it is stated that the state government has constituted selection committee under rule 6/1 of the consumer protection and qualification for appointment, method of recruitment, procedure of appointment, term of office, resignation and removal of the president and members of the members of the state commission and district commission or rules 2020 will be found in the memo entirely. For the purpose of filling up the vacancies, full stop, along with the memo notification, along with the memo notification dated 24/7/24 issued by the Undersecretary to the Government of Karnataka, Food, Civil Supplies and Consumer Affairs and Legal Meteorology Department is produced, which reflects that under the chairmanship of a judge of this High Court, as required, a three-member committee is formed. Learned advocate, learned additional government advocate, learned additional government submitted that not only that the committee is constituted as a the committee has already started the process.
Yes.
Of considering the appointments, started the process for making the appointment.
Yes.
Only for the president post, my lord.
My lord,
Other members, they have not started to appointment, my lord.
my lord, we are in the process of
notified also.
completing, my lord.
When the state government and the committee constituted is in the process of attending to the grievance of the petitioner. In the process, the grievance of the petitioner would be attended. Paragraph. The present petition is disposed of, observing that the process will be completed as expeditiously as possible.
Okay.
Lord, date may be fixed, my lord, or my lord, the time limit may be fixed for them, my lord. They keep on saying from June, my lord. They're not, as on today, my lord, 30 vacancies are there, my lord.
Since the committee is constituted and is faced with the subject matter, no further orders are warranted.
Number 35, to Vinod Kumar, yeah.
No further orders are necessary.
My lord, with regard to proposed impleading application, my lord, I may be permitted to produce one document, my lord, which says that, my lord, the proposed applicant, but my lord, proposed respondent was registered in 1988, my lord. Thereafter, till today, it was not renewed or not submitted its annual returns, my lord. Therefore, it has no locus standi to file any petition. That is my submission. May submit one document, my lord. Well, I may be permitted.
Yes, I have a copy on me, my lord. So I need to seek instructions with regard to this document.
Statute is put up. Statute is put up.
Yes, my lord, statute.
In fact, my lord, the statute is being put up by the impleading respondent society in the property which was executed by the government to us, my lord. Sale deed was executed by the government to the society. In the said property, my lords, after seeking necessary approvals, we have put up the statue. Now, my lords, the prayer in the writ petition is, my lords, to remove the statue. Any orders passed, my lords, will be directly affecting me. Hence, my lords, I am a necessary party to this.
Not to this society, my lord. It was the permissions, what they have produced some documents. All says that it was given to one Mulabalgal Taluku Vakkaligar Sangha. But the proposed respondent herein is Vakkaligar Sangha Mulabagal. that those are all entirely different organization, my lord. Documents they have submitted shows that some of the permissions have been obtained by Mulabagal Taluku Ukkaligar Sangha. That is entirely different from the proposed respondent, my lord.
So you
That
want
one.
time or you want to argue?
I will file rejoinder to their application and objection.
At the request of learned of the petition to stand out, when shall I give? For 12th March.
My lord, interim order may be continued.
What interim?
My lord, interim order not to put up further construction or.
It is already.
My lord.
Reconstructed,
My
inaugurated.
lord,
done
but
by her.
status quo may be directed, or.
No. Status quo of this photograph will order. Go to.
My lord, they have further, they should not construct, my lord. It's not.
Status quo of page 71, first photograph. Status quo of this photograph will.
Previous interim order may be continued, my lord. They only produced some pamphlets
There
to
is
show.
nothing,
that-
but we have already put up construction.
My lord,
It has been inaugurated by we sought permission to the Dashildar. The statue has been inaugurated. There is no construction or anything of that sort is being put up, my lords.
Whatever interim order is operating shall continue.
much.
36 urgent, seal number 37. Saraswati M.
Beg to appear for my lord, representing my lord, R3 my lord, week's time may be granted my lord.
March 11. What is that? Let us.
My lord, this work, my lord, was authorized to my lord certify the marriages.
Oh.
That's on record advocate, my lord, is not well, my lord, is medical follow-up treatment has been out of station, my lord. Only week's time, after Wednesday, any date, my lord.
Wakaf is granting marriage certificate and divorce certificate also. We will not grant much time because this is very important matter.
After Wednesday.
How can you don't have apparent no authority into the Wakaf Act?
Well,
So
you are
it's
only
only marriage
certifying,
certificate.
we are certifying the already certified given by the mosque, my lord, institution, my lord.
Come on, 19th February.
Much of.
Seal number 38. It is Sneha Nagaraj.
Appear for the petitioner in this matter.
My lord,
Keep it more near. When it is kept? 19th of
February.
today is what? Keep. Let it be on 19th, nearest.
Seal number 38.
Like to appear for the petitioner in this matter, your lordship. The instant petition pertains to advanced medical directors. Now,
my
this is
lord,
a-
we have notified, my lord, the appointment of the officers, my lord, at the taluka level and, my lord, the urban development department. My lord may have this next week, my lord. I will produce the, my lord, proceedings of the appointment, my lord. We have complied with the direction.
19th of February.
Much obliged.
Seal number 39. Prakash M. Patil.
Hearing for the petitioner. Lordship, bring for a short accommodation, week's time. Lord.
Why?
On record counsel is not well.
Everybody is seeking time. This is also PI. No. This will go to 21st March.
Much of.
10 to 21st March as requested by learned advocate for the petitioner.
Seal number 40.
May it please your lordships.
Cash for cash.
Here, the BBMP. This is a matter where bids had been issued for implant of microchips in the dogs. Now, in the interim, my lords, though there was no stay granted, but they have come out with another tender. The matter has been sub judice, and that has not been even annexed in their statement of objections. This is the second time around they've come up with a fresh tender, and that has not been brought out to the attention of the court either.
Granted some more order.
That's on seventh evening, they served on me. Next 2 days were holidays, 8th and 9th. They have now produced a bulky 500-page NAPRE guideline without pointing out which part of it is violated.
Well, that has already been brought out in the petition. What has been violated, my lord? These are guidelines of the Animal Welfare Board of India and the guidelines of the National Animal
And in the
for eradication of rabies. These are
and the
guidelines which
tender
have been
which they want to stay, that is not even the subject matter of challenge in the writ petition. What they have challenged in the writ petition is 29/2/2024 tender notification. That my lords declined to stay. That period is over. For subsequent period, not in respect of all items, only in respect of one of the tendered items of 29/2/2024, which is not subject to any animal birth control rules, 9/1/2025 notification has been issued. Now, my lords, without raising a challenge to it, they filed an IA for staying of that, without even pointing out. They have to first raise a challenge to that notification. They have to say what is wrong with that notification. Then, my lords, in spite of it, not they have produced some guidelines. I'll have it gone through and then a appropriate response filed to that NAPRE guidelines. Lords may have it thereafter, my lords.
in the interim, my lord, that status we go. I mean, they cannot issue fresh tender subsequent matters sub judice and they're coming out fresh with fresh tenders. And this is not permitted by the ABC rules. ABC's rules have been mandated by the Supreme Court orders as well as by the Prevention of Cruelty Act. There is nothing in the BBMP Act which permits microchipping. We are not on the point of vaccination. In fact, the earlier exercise of vaccination was already taking place. This entire exercise of microchipping is not permitted by the rules. Microchipping is only for pet dogs, not for stray dogs. My learned friend is not clarifying that part. In fact, there are rules specified, especially under the Prevention of Cruelty Act, that it is only for pet dogs and dog marketing rules.
But have you put the details about the fresh tender on record?
Yes, my lords.
The fresh tender.
Yes, it is on record. And also, in fact, as recently in my rejoinder, 1 minute, my friend. I have, in fact, in the rejoinder also, of course, it's a news item, but Greater Chennai Corporation has specially come out that it is mandatory for pet license for microchipping. Even Greater Chennai Corporation has taken that stand. So it's not something which you are just talking in the air. They are bound by the rules. And there is specific rules only for pet dogs, not for stray dogs. So it's not something just in the air that we have filed this petition. And this tender is primarily only for, let status quo be granted until the next date of hearing, my lords, and thereafter we can examine in detail.
Who appears for BBMP?
I appear.
What is the cost of the tender?
Cost of the tender, my lords, it is not much, but before 31st of March, we have to avail the
No, that's okay. I asked you a specific question. What is the cost?
The cost of the tender, 9/1/2025.
I mean, the contract being awarded, what is the amount spent on it?
That is, my lords, annual turnover, that is.
Amount spent by BBMP, rather, that would be the question.
$2.5 crores.
That is annually, is it?
No. For the entire project.
One-time project.
That is.
Stray dogs in Bangalore.
Stray dogs microchipping so that vaccination effort is not duplicated. What happens is, Manoj, vaccination is being done, but we do not know at any given point of time which are the dogs that are vaccinated, which are yet to be vaccinated. Therefore, Manoj, as a pilot project, based on the internationally available guidelines, we started microchipping and did for about 20,000 dogs.
then what is it proved effective in the sense, that microchip reader will be there. Once we read that microchip reader, we will know what all vaccinations have been done. If whether it has suffered any ill health, all the entire health record will be there in the microchip. So that the duplication of the vaccination effort is avoided, and more effective penetration of vaccination can take place. Their entire pleading in the writ petition is about animal birth control rules. This has nothing to do with animal birth control rules. Their plea is that animal birth control rules do not provide for microchipping. They do not say which provision of any international study says that microchipping is deleterious to the health of the street dog. Yes, my lords, when we issue a pet dog license, certain restrictions are put, which the dog owner will have to take. These, my lords, why I am talking of community dogs. As a community, we are responsible for that. Therefore, my lords, it is the responsibility of the BBMP. In fact, my lords, primary functions in Schedule A to the BBMP Act, this comes, public health and sanitation. And then, my lords, the central government has also started an anti-rabies program. Their idea is, my lord, by 2025, rabies has eradicated. Only if one of the effective means to achieve that national target is to have this vaccination of the dogs done on a wider scale with a deeper penetration.
Now this microchipping will be outside the skin or inside the skin?
Inside skin, it's an invasive procedure.
Microchipping, my lords, it is less than the smallest of the
No,
rice
I
grain.
just asked inside the skin, right?
Yes, my lords.
It's inside the skin.
It is inside the skin. It is inside the skin. It is not open to the vagaries of weather, and it can be read. In fact, in human bodies, if pacemaker can be this one, and in fact, I am myself on insulin chip, and I have been living with that insulin chip for the last 10 years. Nothing has happened to me. In fact, I am every day appearing before. These are my lords. What they say, suddenly they say NAPRE guidelines. And then, my lords, one-page newspaper report they have produced.
No, that, my lord, my learned friend is overstepping with all due respect. That newspaper item is not just produced for the sake of how other corporations are doing it, and specific rules have been provided. Specific rules have been provided, my lords. I will take you through the Supreme Court judgments, why these rules have become important, why these animal birth control rules have been prescribed. Otherwise, it would have not been excluded. Microchipping would not have been excluded in the ABC rules itself. 2023 rules. Why is it provided as a pet dog rules, where it specifically, I'll read the rule, my lord. My learned friend is not giving the
size of a microchip.
Prevention of cruelty to animals, dog breeding and marketing rules. In fact, Rule 9 very clear says, every breeder shall maintain records of all animals housed in the establishment, including dogs for breeding and dogs for
sale. This is the size of the microchip, my lord. This is a
9(2)C is microchip. It's not, first of all, the tender itself is illegal. They do not have the power for microchipping.
That tender, they have not challenged.
We have challenged the tender, my lords. In fact, the IA is also put on record. Your lordship, this is not permitted by the rules. Otherwise, these specific rules only for microchipping pet dogs would not have been permitted in the first instance. There are two sets of rules for microchipping for only pet dogs.
In my lords, in fact, it is less than the normal needle we use for injecting.
When the last date of tender?
Last date of tender is over in the tender notification itself. They are incorporated. This processing will be subject to the outcome of the writ petition, either in respect of this tender or in respect of any other similar tender. Yeah, we've taken all the care. And their main grievance in the writ petition is about not following the animal birth control rules. They do not point out which specific rule is violated.
My lords, even the tender, they misled the tender. The qualification criteria have been relaxed, all of unqualified NGOs to participate in the RFP. The NGOs are illegal entrants and having an inquiry pending against them have been allowed to participate and get into MOUs. It's not, my learned friend, with all due respect, is painting a picture as if it's just some question of one microchip. It's like anything else. That is not the point here. The tender is also flawed. They're allowing participants to participate and it's a financial racket. The annual turnover criteria has been slashed to give these illegal and inexperienced but favored NGOs a wider arena. The targets for ABC have been removed, whereas 70% of dogs have been covered in a single breeding cycle. So your lordship, until the next date of hearing, if your lordship can stay this, then we will have a detailed hearing. Then I'm go down to whatever your lordships decide accordingly thereafter.
Take up. Finally, you take.
That's 2 weeks time maybe, because Animal Welfare Board is the thing.
In fact, the animal welfare, they're supposed to follow the guidelines, Animal Welfare Board, that also they have not complied with. No SOPs which has been.
10th March.
Until then, my lords, if there was stay can be granted, at least status quo till the next, at least status quo, my lords. They are coming out tender after tender with no, and doing what they are doing, my lords. At least some status quo till the next date of hearing, your lordship. Thereafter, your lordships may decide accordingly whether it is fit case or not. At least some status quo, my lords. Then no steps be taken for microchipping until, or the pilot project until the next date of hearing.
Nothing. Sorry. Yes, next.
Well, instead of 10th March, could it be a week later, my lords?
20th, as requested by learned.
Well, obliged.
So this is number 41, Anish Acharya.
I request for a short.
I
so
appear-
Senior counsel is engaged, he's on his way.
I appear for the,
That's my look at the order dated, my lords, 9/12/2024. That's, this is a matter, my lords, where they sought for an extension of an EC which has been revoked. And they made a statement that, my lords, let them give the extension, then we'll deposit the money. But my lords had indicated, my lords, in the order that they should deposit the money and my lords would direct us to, or the CR to extend the EC. That's, as of now, my lords, I don't see any positive statement by the petitioner that if they have deposited the money of 117 crores till date. And my lords, this amount has reached finality, my lords, whereby the orders of the NGT was challenged before the Supreme Court, my lords, and it has been dismissed. So, no, my lords, they're trying to, even the interim order which they were seeking was to stay of the proceedings.
A short pass may be granted, my lord, make my submission, senior counsel is engaged.
I appear for the impleading applicant.
26th March.
My lord, a shorter date may be given, there is an execution petition which is.
May I make one
May be granted, my lord. Pass over to the 2:30, my lord.
May I make
Certain
one
urgency
submission,
in
my
this
lord?
matter, there is a NGT matter which is being proceeded.
I appear in those, if I may make one submission, my lords.
Any urgency?
That's the urgency, we don't have no urgency, my lord, except that they have to
before
pay the money to us.
Execution before the NGT is listed on 19th, my lord, of February. They're insisting on the payment, my lord. That is the reason. I'll make a submission, my lord. Kindly be passed over.
That's, that cannot be interfered
let
with
the-
us with
let-
greatest
let me
respect,
be-
because
let-
my lords have
let the
already
si-
expressed their opinion that the money has to be deposited.
25th February.
Before 19th, any date, my lord. Before 19th is the date where is NGT is listed, my lord.
NG is listed.
Listed before 19th. Any date before 19th, my lord, if lordship be,
17th.
please, man.
That's, the execution is for the payment of the money, and
But that
it was
is-
undertaken by the petitioner, they will pay the money. And the lords have recorded that in the order sheet. And I don't see the argument where it's heading towards, even in terms of adjournment or Passover.
I'll make my submission.
When
my lord.
undertaking
Let
has
me-
been
let me
given
be
before
heard,
this court.
Maybe taken up any time before 19th, my lord, I'll make my.
14th. We'll try, take chance on.
Much obliged.
42 is agenda number 43. Ramatullah Katwar.
For the petitioner in this case, your lordship, the matter pertaining to illegal construction of shops in public passages and fire exit places in KR Market. Your lord.
Replies.
We're pleased to.
No, let's find my vocal, then find my response. Note.
Your lordship's kind intervention, my lord. I appear for the BBMP, my lord, a similar case. My lord, my friend is appearing here, because in fact, there was another case, my lord, in which contempt has been adjourned. 28 March.
Much obliged.
28 March. So 44, 45 are urgent, number 46. The Prashant Rao, party in person.
Lordship,
Who are you? You are there.
I'm
Lordship, this case concerns to handrail to be put on the footpath, Your Lordship. I made a lot of petitions and requisitions been went for this authority. They have not taken any action, Your Lordship. And even I have invited to this particular road through a email also to come and see the road, Your Lordship. Every house, the parking space is being given to commercial trade, and they have taken over the whole place, and there's no parking space also. I'm just asking for a small piece of footpath to be protected, Your Lordship. The whole place is being given, and I've given even petitions before the Honorable Ward Committee also to remove the particular encroachment on the footpath. They've not taken. And there's a concrete work is happening from past 3 months, and I've even spoken to them. 3 more months is going to take, and be taken. There's no space to walk or either travel in the vehicle, Your Lordship. I've given all the photos, and this concerns to the IA, where I've given the particular copy of the video to the particular legal counsel also of the government advocate, Your Lordship.
We do not know the subject matter unless you explain. We are not habituated to board the bus in.
I'll come back again.
To start from the beginning, what do you explain to us, what is the matter? We are unable to, you then come with your lawyer.
Your Lordship.
We are not here to waste our time and your time. Yes.
This is a footpath in Tyagaraja Nagar, first main road, Your Lordship. This footpath is not protected, and the remaining footpath has all been encroached. I have made this petition for the Honorable Court as per the handrails thing to be put in this particular path, which is just around some 18 feet, Your Lordship, so that everybody can walk safely on the footpath.
That is their business. Yes, when he replies back. My lord,
My lord.
I filed my statement of objection. This is the third round of litigation, my lord, in respect of the same footpaths. If
Where
your
is your
lordships
reply?
make, my lord,
To file your reply.
yes, I filed it, my lord.
26 March.
Reply. My lord, my statement of objections have already been filed.
Very, well. We'll see it.
Very well.
Number 47. To Manjunath Rao.
Matter, my lords. The city municipal council had filed a writ appeal, my lords, and which has been dismissed for non-prosecution. The state is also taking steps to file the writ appeal against the order passed by the learned single judge, my lords, on 20th December 2023, my lords. Pray for a short accommodation, my lords, 2 weeks' time.
No, direction only to the particular accused, my lord. There is no direction who has filed the writ appeal, my lord. No, my lord, unnecessary taken time. And this appeal also dismissed for non-prosecution. This is, my lord, this is the third round. She is litigated, my lord, more than 5 years. Earlier, my lord, she has she has been considered for appointment in as a Gram Panchayat employee, my lord. The Gram Panchayat is converted into a municipality. Thereafter, my lord, once again I filed a writ petition. In the writ petition, this honorable court has directed that the father of the applicant, complaint, my lord, is a municipality employee and considered his case for compulsory ground appointment. Since, my lord, 5 years he is litigating.
In the writ petition, my lord, respond number 3, that is the director of municipal administration, was the directions to consider the case of the petitioner, my lords. Now the state is filing a writ appeal, my lords. Say for 2 weeks' time, my lords, we will report the status of the appeal, my lords. I need some time.
Appeal is filed.
It to be filed by the state, my lords.
No, yet to be filed is no answer.
City Municipal Council had already filed the writ appeal, my lords, but it has been dismissed for non-prosecution is what I have seen from the status of the case, my lords.
And this writ
Date
petition, my lord, the direction only to this accused, not for the municipal chief commissioner, chief officer, my lord.
Just because there is a noting in the cause this about the filing of the writ appeal, I'm clarifying on that, my lords. I'm not defending the act of the municipal council. I'm requesting this honorable court, my lords, that 2 weeks time is granted, my lords. We will do the needful, my lords.
For compliance.
No, my lord, I'm informed that writ appeal is being filed, my lords.
So that is what I was asking. It is filed or not?
Not yet filed, my lords.
Then you comply with.
Kindly pass it
So
over. my-
December 2023, you are not even deciding the,
No, writ appeal, almost done, my lord. Some documents they're looking forward
do
to.
not consider the case of appointment.
We'll file it today, my lords. May kindly pass it over, my lords. We'll report the status, my lord.
Only you have to pass some order, yes or no. That's all.
May kindly pass it over, my lords. By afternoon, I'll report back to this honorable court, my lord, about the filing of the writ appeal. There was already a complaint affidavit was filed, my lords. But
That
with
is-
regard- that is on filed on 21st June 2024, my lords. Lordship, may kindly see paragraph number 2 and 3, my lords. 3 is the relevant part, my lord.
What is the time limit to file the writ appeal?
There is also a delay in the,
What is the time limit to file writ appeal? Under section 4 of the act.
the order was passed on, my lords, on 20th December 2023, my lords. There is delay also in filing a writ appeal, my lords.
No, what is the time limit to file the appeal?
30 days, my lords.
30 days. So this affidavit of compliance you are filing on 5/6/24 and telling that we are contemplating appeal.
Because as on that day, my lords, on 21st June 2024.
Now you decide carry out the direction or let the commissioner remain present.
Moreover, my lord, the writ appeal filed by the is not a aggrieved party, my lord. Only direction to the third respondent who is the accused here.
Question was for the third respondent who has filed the complaints affidavit on 21st June 2020.
There is no compliance. What is this?
Please, that was the status was in week's time may be granted, my lords. A week's time may be granted, my lords. Because the state is taking steps to file writ appeal, my lords.
Only direction of learned single judge is to consider the case of the petitioner on complaint ground and pass affidavit orders within 2 months. This direction is issued to respond number 3, Director of Municipal Administration, Bengal. Full stop. Not only that, no action is taken to consider the case of the petitioner as directed by learned single judge, comma. In the compliance affidavit, which was filed 6 months after the date of order on 5/6/24, it was stated that writ appeal is filed and is pending consideration against the writ petition wherein the order is passed. Writ appeal is filed.
On behalf of the state is still not yet filed, my lord. This was filed by the city municipal council, my lords. On behalf of the state is yet to be filed, my lords. In another 2 days, it will be filed, my lords. This was filed on behalf of the city municipal council, my lords.
The said writ appeal was stated to have been filed. The writ appeal number 633 of 24 is stated to have been filed by the city council. However, no progress is shown. Full stop. Not only that, when the present contempt petition came up for consideration today, learned additional government advocate, Mr. So and so, had an audacity to submit, to seek time on the ground that the state is also wanting to file the appeal, though it is an admitted position that no steps are taken to file the appeal. Full stop. The conduct of the respondent number 3 is contumacious and mere partake the contempt itself, unless the necessary steps are taken within the time indicated hereinafter to purge the contempt. Full stop. Therefore, this contempt petition proceeding contempt proceeding adjourned to 28th of February, within which, unless appropriate orders are obtained in the appeal and shown to the court, comma, the compliance shall be shown. Compliance should be demonstrated before the court by filing affidavit. If the compliance is not shown in the event of in the absence of any orders in the appeal, respondent shall remain personally present before the court. If the compliance is obtained, the personal presence will be automatically stand dispensed with.
Bill number 48.
For the complainant in this matter, my lord,
That's,
48.
they have not filed the reply, my lord, the accused number 1 and 2.
That's may make one request.
The necessary steps have been taken in this case, my lord.
There's a writ appeal, my lords, which is being filed. Writ appeal number, my lords, 1482 of 2024. This is with regard to payment of some gratuity by the Pollution Control Board to the petitioners, my lords, or the complainants here.
The DNS allowance is not being considered by the respondents, my lord. They have filed a writ appeal, but there is no status quo or stay on the appeal file, my lords.
That's I would only request, my lords, let it be tagged along with this contempt. We want to proceed with the writ appeal, my lords, because there are certain submissions which were not noted by the learned single judge.
My lord, the order has been.
Writ appeal number?
Writ appeal number, my lords, 1482 of 2024.
It was stated by learned advocate Mr. Mahesh Chaudhary to the respondent court that the writ appeal number 1482 of 24.
24, my lords.
Before is filed in respect of the order and contempt. In that view, the present contempt proceeding may be listed along with the said writ appeal. However, on the next date, the respondent board shall recompute the gratuity amount payable and place the details on record of the contempt proceedings.
Please.
Stand order
That's it.
11th March.
It's number 49. To Prakash T. Ebar.
Lords, in this matter, my lords, the directions are twofold, my lords. One is to prepare the Lebanese sketch. Thereafter, once they have to submit that Lebanese sketch along with the decree order, then the Tashildar to mutate the revenue records, my lords. My lords, in respect of Lebanese sketch, since there are 6 survey numbers, this is the work in progress. Lords, we have prepared sketch in respect of 75/1. My lords, may I pass on the status of the Lebanese sketch? Lords, there are totally 6 survey numbers, my lords. In respect of the first survey number, PODI is already done. First 2 survey numbers, PODI is already done, and we are to do the Lebanese sketch, my lords. They have filed the application. In respect of 42/1 and 75/1, sketch is already issued, my lords.
After 40, sketch is prepared.
Please, my lords, after PODI sketch. And in respect of last 2 survey numbers also, PODI is already done. They have made an application, and we are doing the Lebanese sketch. Lords, in so far as mutating the revenue records is concerned, Lords, the opposite party, this is a Patta land, they have obtained a stay order from the city civil court, my lords. This order is here. May I pass on this?
What is this stay in the court?
Not to encumber, no, the stay is defendants are restrained from alienating, encumbering, or
Some civil proceedings.
civil. So Lebanese sketch, there's no
Assist revenue authority.
No, it says stay in AC court. It can't be.
No, my
not
lords,
to-
here, that is wrong, my lords. Here is the stay order.
So they are shown the progress.
Minutes, now they filed the report. I'll look into minutes. I'll take instructions of my client also.
So the report amounts to, sir, what is the direction? They have substantially.
This is
progressed.
partly done, my lords. This is not complete.
Partially,
Yes.
substantially it is done. What time you expect to take, madam? What time you expect to take?
Another copy. My lords, in so far as conducting the Lebanese sketch, my lords, another 3 weeks, my lords, but to enter the revenue records, there's a stay that is operating, my lords.
Except the matter where it is stay.
My lords, may kindly observe that we will complete the Lebanese sketch because the stay might come in the way. If there is a direction,
Will this stay matter will be excluded, but rest of the matter will be able to comply with the direction within 4 weeks?
please, my lords, there may be a direction to that effect. my
I'll
lords.
seek instructions, my lord. I may be permitted to make submission in next.
What instruction?
In regarding to the stay, which is granted in AC court.
So these directions pertain to 6 matters.
Please, my lords, the representation is with respect to 6 servants. So, court officer. There's some directions, my lords, we will comply, my lords.
This interim order is not pertain to not conduct of 4 or.
Therefore, I submitted, we will complete the Lebanese sketch process, my lords. Only with respect to mutating the name, there is the
Direction
direction
is not encumbering, is it? The directions of law on a single judge dated in order dated 4th January 24, while disposing of the writ petition pertain to requiring the disbursement to Assistant Commissioner, Assistant Director Land Records to complete the proceedings of conduct of 40 and preparing 11 E sketch, etc. For my read is under paragraph 6 to be quoted from page 13. A representation was made paragraph by the petitioner dated 25/9/2020, making the grievance in the above regard. The representations involved 6 cases, different survey numbers, situated at Chikka Nahalli village and Enjiga Nahalli village. Paragraph. When the present proceedings came up for consideration today, learned advocate, learned additional government advocate, Srimati Nilofaram, Pramod Kishan, produced the tabular details showing the progress done in each of the 6 cases in light of the directions issued by law and rules. The tabular details are reproduced herein. This is paragraph. The above detail shows that in 2 cases 40 is already done, whereas in 1 case sketch 11 e-sketch is also issued. In 2 cases, new applications are made, which are already under process. 1 case is indicated where it is shown that the Court of Assistant Commissioner has granted stay. Paragraph. When learned additional government advocate produced copy of the stay, it transpired that the stay was on stay granted in case of survey number 42/1 in question was only in respect of alienating or encumbering the property. Full stop. It would not per se prevent the authorities from conducting coding and repairing a sketch. Full stop. The authorities, the competent authority is already in the process of complying with the directions of learners in values. The present contempt petition is disposed of.
My lords,
in
one
view of the
submission.
substantial
In fact,
progress
there are
done-
other survey numbers, my
in view
lord.
of the substantial progress done, by issuing following directions. Full stop. In the cases of survey number 1, in the cases of survey number 4, and survey number 10/1, where the 4D is done, the rest of the formalities leading to mutation of the entry shall be completed within 4 weeks from the date of receipt of the certified copy of this order. 2.
My lords.
In respect of land survey number 75/1, where the 11 sketch is already issued, the mutation shall take place within 3 weeks from today. 3 weeks from the date of receipt of the certified copy of this order. 3. Where new applications are in process, which are in respect of survey number 4/4 and 10/7, the complete exercise will be completed within 8 weeks from the date of receipt of this order. Next. In respect of survey number 42/1, where the stay of the court of the assist commissioner is shown, sorry, stay of not assist commissioner, stay everywhere in place of assist commissioner. In the proceedings of original suit number 192/25, whereby the defendants are restrained from, what is the order? Alienator or encumbering the.
Lords, if the
subject of
same is
land,
vacated, I may be liberty.
the all entire proceedings except mutation
Please.
shall be carried out within 8 weeks,
Obliged.
6 weeks from the date of receipt.
My lords, in fact, there are other 4 survey numbers, my lord, which they need to be, Lebanese.
Mutation shall be carried out, wherein it will be indicated that this mutation is subject to the outcome of the proceedings of the original civil suit number 192/20.
My lords, other than these survey numbers mentioned here, my lords, there are other 4 survey numbers, my lord. There are some anomalies in entries in column number 3 and 9, my lords.
Any other survey number is involved?
Yes, my lords, it is there, my lords. They have not whispered about that survey
In
number.
your representation, it is involved.
My lords?
In your representation, it is involved.
Yes, my lords, we have mentioned it.
Where is your representation?
My lords, in page number 19, my lords. Survey number 14 is not reflecting. my lords. Survey number 14, survey number 2.
What about the other?
Because they have
Survey
not,
number
in
18.
respect of the other survey numbers, they have to make an application which they have not yet done as per my instructions.
This stage,
My lords, there are some anomalies in entries in column number
That
9 and
is a
11. my
different
lords.
cause of action.
state learned advocate for the petition complainant stated that the representation also mentioned other survey numbers, which were 2, 5,
Oh.
15,
18,
18,
14, 5 and 2. my lords.
14 and 18, which are not dealt with by the authorities. In respect of the process is not undertaken by the authorities. In this regard, it was stated by learned additional government advocate upon instructions that in respect of the said survey numbers, no applications
No
have been
applications.
moved by the.
Yeah, we have
complainant.
given the
Full
representation,
stop.
page number.
Full stop.
Please.
Learned advocate further, learned additional advocate further stated before the court that if the applications are moved, necessary steps will be taken in light of the directions of learned single judge in accordance with law within a period of 12 weeks.
Obliged.
And the process, and the exercise shall be completed within a period of 12 weeks.
Obliged.
Obliged. Obliged.
With observations, directions and the observation, the contempt petition is disposed of, has not survived, it is disposed of. Next.
Cell number 50.
For the
Ganpati Bhatt.
extrema one, your lordship, in this matter, I seek short accommodation, your lordship. I seek short accommodation, your lordship. Order has to be complied. I have to file translated copies all are there, your lordship. I have to file it. Short accommodation, your lordship.
It is only deciding the representative.
Please, your lordship.
Learned advocate Miss so and so states that within the time which the court may grant, the compliance will be
Please,
obtained. Was to extend over to 19th March.
Please.
51 is urgent. Cell number 52. So Devaya.
Appear for accused. In the morning, I have filed a wakalat for accused. A 2 weeks time may be granted to file my reply. Because after the order under disobedience is passed, there are several communications exchanged between the complainant and the accused. That has to be brought on record. A week's time, I'll file.
An affidavit submitted before the learned single judge in the appeal proceedings, my lord, that they will complete the project on or before November 2023. It is now, despite almost 1 year and 6 months having been passed, page 40 is the order, my lord.
What is the direction, Mr.?
Direct page 40, my lord.
48.
Page 40. This is an assurance given by the accused before this honorable court. Page 40 on the basis of an affidavit to say that they will complete the
Page 40, it is part of the order.
Yes, my lord. Page 40 is a part of the order, my lord. May I read, my lord, the first paragraph? The appellant will be able to accelerate the construction work from 1/11/2022 since the respondent has recorded its no objection for setting aside the impugned injunction order dated 29/3/2022 passed in commercial A 125 of 2022. The appellant shall complete the construction work in all respects and obtain the occupancy certificate by October 2023, and the buyers will be able to occupy the apartments from November 2023. The schedule of work is as stated in Annexure A produced along with this affidavit. This was submitted as an affidavit before this honorable court. And it was on the basis of this affidavit, my lord, that the petition came to be disposed of, page 48. Page 48 is the order passed by this honorable court, my lord. May I read the last paragraph, paragraph 7, my lord? In that view of the matter, the appeal is disposed of in terms of the affidavit. The parties shall strictly abide by the terms of the affidavit filed by each other into this court without giving any room for any further delay or complaints. The appeal stands disposed of accordingly.
So the period is about completion of work.
Completion of the work. They are the developer, I am the landowner there. Completion of a multi-story residential apartment project. They were supposed to complete it in November 2017. The project was delayed. In 2020.
It was to be completed within what time?
It was in terms of the original joint development agreement, it was to be completed by November 2017.
No, not agreement. You are saying some affidavit was.
In terms of the affidavit, it was to be completed by November 2023.
Where is that direction?
Page 40, my lord. That was the affidavit given, which I just read. Page 40, the affidavit given by the accused before this honorable court. Page 40, which I just read, my lord. That was an extract of the affidavit. And in pursuance to that affidavit, this order came to be passed.
Correct.
My lord?
Where is that extract?
My lord, page 40, my lord, which I just read. I'm sorry, my lord. It starts at page 36. The affidavit is extracted.
Read the relevant part of the extract.
May I read page 40, subparagraph 1. May I read from line number 6.
Appellant
shall complete the construction work in all respects and obtain the occupancy certificate by October 2023, and the buyers will be able to occupy the apartments from November 2023. The schedule of work is stated in Annexure A produced along with the affidavit.
This is part of the affidavit? Or?
This is part of the affidavit. This is extracted. And it was on the...
So it is not done?
My lord?
Not done.
This has not been done. I have produced the photographs as well as, my lord, admittedly, they have obtained They have, without my consent, obtained a RERA extension till December 2024, which itself demonstrates that they have not completed the project.
Then the RERA extension is obtained, then what we can do now?
Not, may I make the submission, my lord? RERA extension was not permissible. Had
You challenge it.
that is, I have separately challenged. That is a separate proceeding, my lord. But before this honorable court, there is a contempt of the order of this honorable court, my lord. That is my submission. I have produced photographs to show that they have not completed the project, even as on date.
I pray for a week's time, I'll file a reply. Because after this order under disobedience is passed, there are several communications exchanged between the complainant and the accused. That has to be brought on record. That is not a part of a complaint.
What?
After this order under disobedience is passed, there are several communications exchanged between the complainant and the accused. That is not the not part of complaint, this complaint.
What is not part of it?
After this order under disobedience is passed, there are several communications exchanged between the complainant and the accused. That is not made as a part of this complaint.
There are several communications between the developer and the complainant.
Please.
Which are not part of this process. What does they say? What
That I'll
does the
file, that I'll bring on record along with my reply.
You must be knowing what the communications say.
In the
For what
morning, I have
purpose?
filed a wakalat, my lord, no clear instructions, but this is the instruction.
4th March.
4th March. To file the reply. To file the reply, my lord.
You are filing reply. For which state the compliance affidavit shall be filed.
Grateful.
Reply come compliance. Reply shall be.
Bill number 53. So Shashidhar S. Ramadi.
Petitioner. Complaint. The respondents have to file their reply in this.
Not filed.
Not.
No need to file this. Who is appealing? Who will be opposing you?
Mr. Ajay M. Ajay Kumar M.
Surely pass over.
Please.
Pass.
Number 54. Ashok.
My lords, in this matter, the complainant, your lordship.
Paper for accused.
After passing the interim order by the learned single judge, your lordship, the accused has continued to violate the order by constructing the building in the property, your lordship. The order is in page number 42, your lordship. Para number 7, my lords. In the event of no such plan having been sanctioned, to ensure that no further construction takes place in the survey numbers, your lordship.
What happened to the writ petition?
It is still pending, my lords.
Construction is going on.
Now it is stopped, my lords.
Stop.
Now it is
Was
stopped.
stopped in 4/11/2023.
4/11.
4/11/2023, my lord. My lord, the photographs he has also produced, I have also produced. If your lordship can see both the photographs have the same angle as on the day when I filed the compliance affidavit, I have produced.
It is in the same situation, my lord, only one wall. He has taken on 31/10/2023 photographs. I have to, my lord, I have stopped on 4/11/2023. Only one wall have been plastered. That's it, my lord. Thereafter, my lord, after coming to know of the interim order in the complaints affidavits also, I have stated I have not put up any construction. It is stopped as on today. It is stopped, my lord, on 4/11/2023 itself. It was stopped.
My lord, yes, on today it is stopped, but pursuant to
on
the order
4/11,
passed by the
2023 it was stopped.
Honorable Court, it was continued, and the Tahsildar
They-
has also issued notice on 14/5/2024,
Your Lordship,
asking
you
him to
kindly
stop
see
the
photograph.
construction, Your Lordship.
Your Lordship,
The
you
order
kindly see
dated
the
11
photographs in both the complaints affidavit and contempt.
It is the order dated 11/10/23, passed by alone a single judge in the pending proceedings of writ petition number 17561 of 2023, which is brought under the contempt jurisdiction. The relevant part of the order reads as under page 38, paragraph 6, 7, 8. The aforesaid order was passed on 11/10/23. Admittedly, the said order is interim order in the proceedings of current proceedings of the writ petition, which is pending for a single judge since 2023, to be considered on merits at large. Not only that, it was stated by learned advocate Mr. So-and-so, the respondent, that pursuant to the said interim order, construction was stopped on 4/11/23, which is reflected from the photographs produced on record. Full stop. This factual aspect
My lords.
is correct.
No, my lord, he has continued to construct. Even on 14/5/2024, Tahsildar issued notice asking him to stop the construction, Your Lordship. The accused is a police officer.
Sought to be
Yes,
disputed.
deliberately violated the order of the Honorable Court.
Was
Your
sought
Lordship.
to be disputed by learned advocate for the complainant. Full stop. Whether the construction is continued or not, post the date of the order dated 11/10/23 is to be gone into upon leading of evidence. Well, I'm full stop for this reason as well as for the reason that the order is interim in nature. This court is not inclined to go into the issue whether contempt is committed or not by exercising the jurisdiction and the Contempt of Courts Act 1978. Parties are at liberty to work out the rights and remedies before a single judge. Full stop. Since the petition is of 2023, a single judge may be requested by the parties to take up the petition expeditiously. With the aforesaid limited observation, the contempt jurisdiction is, the contempt petition is disposed without going into the merits of any of the aspects of the controversy.
Number 55, Mr. T and Vishwanath.
Waiting for appellant, my lords. My lord, senior counsel is on his legs before another court. Senior counsel is on his legs before another court, my lords. With regard to the maintainability, he will be submitting on the matter, my lords. With regard to other office objection, it will be complied within weeks, my lords. Weeks' time may be granted, my lord. I pray for weeks' time, my lords, to comply office objection.
Weeks' time. 7th, as requested.
This is number 56.
In 56, I have to appear for the.
I have to file objection to the two applications, my lord. There is an order of status quo. So I'll file it in a week's time. It's a secured instructions.
15th March.
Interim order is there of status quo.
Additional government educators. Paresh. Interim orders will continue to operate till the next.
Number 57. Grateful.
My lord,
Mr. Nagaraj.
57 I appear for the appellant.
My lords, maintainability issue is raised, but it would not arise, is my humble submission. Because if my lord sees the writ petition, in fact, the prayer in the writ petition, my lords may just see the prayer which is at page 31. Prayer was only for expedited closure of the divorce petition. Kindly see page 31. So it would not actually be a 227 issue where there is an order of the lower court.
Page?
31, my lords may see.
Page?
Page 31, my lord. Page 31, the prayer in the writ petition before the single judge. Prayer is only to dispose of the MC petition within some expedited time frame. Page 31. It is not actually challenging any order of the family court. So therefore, the maintainability issue raised on 227 may not be correct. Because it is an original petition. It is not against an order of the family court. So therefore, the maintainability objection may not be there. In fact, my prayer is only to expedite it. Tamanna judgment is there. Yes, Tamanna judgment, there is no difficulty. My lords may in fact see para in the, if my lords have the ILR page 120. It is only to expedite it within a short time frame. Even if my lords were to say within 6 to 8 months to close the matter, that's all. It matter has been going on since 2018, the divorce petition. And in fact, the grounds on which the learned single judge has rejected it.
Why are you preferring appeal?
I'm sorry.
Why you are preferring the appeal? It says that.
My lords, we just want some direction by my lords, some direction, even if my lords would say 1 year to to dispose of the matter. That is all. From 2018 petition is filed. From 2016, almost 10 years they are separated. There is a small child. No maintenance is given. Divorce is not passed. 10 years it has happened. We only want some expedited.
Who is opposing?
My lords, we'll serve the council on record. Notice is not issued. We'll not yet issued. If my lords issues notice, we'll serve the council on record. And some time frame may be put. That's all. We don't need anything else. We'll serve the council on record in the lower court. Yeah. Yes. There may not be any opposition from the other side also, because ultimately it will benefit both parties if there is some timeline given.
Come to page number 15, your writ petition.
Writ petition, my lords. Yes, 227 has been put. No, we have seen that. We have seen that, but that is an error. Ultimately, the prayer is not against an order of the lower court. For a typographical error by the council, there are, my lords are well aware, that cannot be taken as a ground. No, 220.
Read Article 226. It's excess of superintendent's power of this court over.
In fact, there is an order which my lords would know also by this honorable court, a division bench judgment, which in fact says that from a final order, even 227, the appeal would be provided. My lords would be aware of it. In addition to Tamanna, even after Tamanna, can I just pass that on? In a final one, this is in fact a 2024 order. May I just pass that on, my lords? May I just pass that on? Can I just pass it on, my lords? In fact, this is an order of this honorable court. Could I just pass on this in Paschim Vibhag Shikshana Mandal? It's a 24 order. In fact, on the same issue, this honorable court, may I read out page 14 internally, my lords? May I read out from page 12 onwards? Page 12 onwards. In fact, this honorable court, in fact, clarified even tamanna, page 12, ordinarily, the line that starts ordinarily. After the extract of Rule 4, may I read from there, my lords? Ordinarily, the power exercised by the constitutional courts under Article 226 is in the nature of original jurisdiction, and therefore orders emanating therefrom may be termed as original judgment, order, decree, the expression employed in Section 10(4)(a) of the 1961 Act. There is no dispute that orders made in exercise of such powers are amenable to challenge in intra-court appeal as provided under Section 4. However, when it comes to an order passed under 227, it cannot be gainfully argued that it is a product of exercise of original jurisdiction as such. It has long been settled that the power constitutionally vested under Article 227 is special, limited, and supervisory in nature and content, vide Radheshyam versus Chabinath. However, that does not mean that the legislature cannot provide an appeal against an order passed under this Article 2. A right of appeal is created by the state legislature by enacting Section 4 of 1961 Act as mentioned above. The scope of this section has to be determined in the context of Section 10 of the Act in general and Clause 4A thereof in particular. Then the Section 10(4)(a) is there. And 4A, which this Honorable Court relies on, is an appeal from any original judgment, order, or decree passed by single judge in exercise of powers under Clause 1 of Article 226, Article 227, and 228. Thereafter, on the next page, this Honorable Court holds, a plain reading of this clause leaves no manner of doubt as to orders passed inter-alia under Article 227 being appealable regardless of the limited scope of such appeal. The expression original judgment, order, decree employed in Clause 4A of Section 10 of the 1961 Act, which Mr. So-and-so vociferously highlighted, is confined to orders passed under Article 226, which indisputably vests original jurisdiction in the High Courts as contradistinguished from appellate, revisional, or supervisory jurisdiction. It is Article 227 in contrast, which vests supervisory jurisdiction. However, that does not bar the legislature from making even such orders appealable if it so chooses. Thereafter, my lords, next page, page 15, this court considered tamanna. In Tamanna, on the next page I'm reading, in Tamanna versus Renuka, what was discussed was the appealability of interim orders passed in writ jurisdiction, more particularly under Article 227. Whether a final order passed under Article 227 is appealable or not was not even in the penumbra of the said decision. It hardly needs to be stated that such a decision is an authority for the proposition that it lays down in a given fact matrix only, and not for all that which logically flows from what has been so laid down. Lord Halsbury laid down so-and-so, my lords. And thereafter, in this case, even under 227, this Honorable Court held. My submission, my lords, is twofold. First of all, my inclusion of 227 itself was perhaps erroneous on the part of the council because it was not challenging an order of the family court. This was only, a writ petition was filed only seeking expedited hearing, which in fact, even under the case flow management rules, my lords are, yes, just give 2 copies. There are rules which require some cases. In fact, the Family Courts Act says speedy disposal. Yes. The case flow management in subordinate court rules, in fact, this is passed by which shows that for divorce and family cases, within 12 months, it should be disposed. My lords, we are here where almost 8 years are over. In fact, even may I just pass on one more decision? May I just pass on one decision? The Honorable Supreme Court in matrimonial cases has in fact held that family courts should expedite matters. Can I just show my lords? My lords, just 2 lines.
Yes, madam, it has to be expedited, but it cannot jump seniority, no?
No, it may not jump seniority, but it's a 2018 matter. We are not saying it should
But
jump.
Is it
may-
your
may-
case that there are no other 2018 or matters older than that in that court?
There are barely any, no, there will be some, but in numerous matters, in fact, numerous matters, my lords, where my lords feel that it should be expedited. There is a small child in the picture. From 10 years, the parties have been apart. And my lords, respondent has been dragging the matter by filing at least more than 10 IAs have been filed. What is a single woman struggling to even get maintenance for her child? How is she supposed to manage, my lords? In fact, the Honorable Supreme Court, it is just to keep that in mind. Whatever timeline, my lords,
Notice written.
grateful, my lords, much obliged. We are really grateful. We may be permitted to serve the council if my lords permit.
In addition to normal mode of service. In addition to normal mode of service, counsel for the respondent who appeared before learned single judge may also be served.
Grateful. We'll take notice. my lord.
The issuance of notice does not reflect positively on the aspect of maintainability of the notice. When shall we keep it?
My lords may keep it
20th March?
20th March. Oh, I was also hoping 20th February. First week of March, at least, my lord. First week, some date
6th
maybe.
of
6th. 5th, my lords. 5th, great.
Number 54. Number 58.
Here for the petitioner in this case, my lord. My lord, I have, my lord, today it has been posted for rectification of the office objections in respect of respond number 2's objections, my lord. Respond number 2 and 3 in the second set. I am appearing for the petitioner, my lord. I have just sought for writ of certiorari for quashing the order passed by the Mangalore Mahanagar Palike. They have to rectify the errors, my lord, the objections, office objections.
So you have to remove the office objects.
My lord, they have to do it, my lord.
Second respondent has to remove the office objection, Your Lordship. It seems that he has filed the second set of the statement, written statement, but if some objections has raised in the office, that has to be rectified.
What are the?
Annexures is not forthcoming.
Then second set you have to support. Apply second set.
Please. To comply the second set. Your
Not
Lordship.
me, my lord. Respond number
Oh.
2, they have to comply. So date may be given, my lord.
The
for
office objection is in nature of non-supply of the second set of reply.
Responding.
Statement of objections. These state's office's objections shall be complied with on or before 27th February, failing which the petition shall,
My lord,
failing with the petition shall be listed and the respondent shall lose right to reply.
my lord, date may kindly be given, my lord.
27.
Obliged.
With serial number 77, Lord, state has also filed an appeal. Lord, that may be taken along with the writ appeal number 1526 of 23 filed by the state. Connected.
This is for office objection.
I'll rectify that. Week's time may be granted.
So that will do in the recess after.
I'm great.
My lord, serial number 67, my lord, may I request to be taken up next week, my lord, some inconvenience today.
67.
67.
PIL.
Please, my lord. I've already filed an affidavit having,
10th March.
Please.
68, my lord. Office objection, I try to comply.
Opposition will deal with in the after.
Let serial number 61, it is fourth time journey, whether it is continuing or not.
Pardon?
51 serial number.
51. 51.
61, my lord.
61.
61, 61.
What do you want?
It's a matter of illegal display of the MLA's photographs at the cost of the BBMP authorities. They are not filing any objection. for the
My
last
lords,
five- four,
my
5
instruction
years,
set's
my lord.
complete. I've been given photographs where all the photographs of the sitting legislative assembly members have been taken off. I may be
No,
granted 2 days'
no, no.
time to file my report, my lords.
My lord, no, my lord, yesterday also on 26th, 27th was hearing, they have displayed continued. Just on the day of every hearing, they are closing by a paper. Very next day it will be removed. It was permanently constructed at the cost of the BBMP funds, my lord. It is against to the contrary to the decisions of the Honorable Supreme Court as well as this court, my lord.
I may be
They're
granted a
not
week's time.
removing-
I'll file my response in this, my lords. My instructions is all taken off.
Okay. Can show it,
Put in
this
a-
photographs very
I'll
differently.
we'll take up, when we'll take up the matter, we'll see the photo.
Next,
Can you confirm it around the 5.5 car road? Main road. In a double way. That's very
The passover matter, seal number 53.
My apologies, my lords. By the time I could reach, my lords, it was a little late. My lords had to pass over the matter. I apologize for the same.
Doesn't matter, proceed.
Please. My lords, we have filed writ appeal against the order which has been passed by the learned single judge. In writ appeal number 1865, my lords. We have filed writ appeal against the order which has been the order which it's been argued, my lords, that we have not followed, my lords. We have filed writ appeal challenging the said order, my lords, in writ appeal number 1865/2024, my lords. The same is pending. Lords, may kindly have this matter after some time, my lords, along with the writ appeal itself, my lords.
Appeal is filed.
Appeal is filed.
When it is coming, when it is coming up.
But we have to move the matter before my lords now. So we have filed it, my lords, in
My lord,
December 2024.
You have to yet to file.
We have filed, my lords. It is filed. It is filed, my lords.
What is the date of all it? August 24. It was stated by learned advocate to the respondent, Mr. So and so and so, writ appeal number
Writ appeal number 1865/2024.
185 of 2025.
24 minutes.
185.
1865 of 2024.
185 of 2024 is referred in respect of judgment and order which is subject matter of this contempt petition. In that view, it is directed that this contempt petition shall be listed along with the said writ appeal on.
my lord, they have not yet complied with the orders passed by the learned single judge of this honorable court. And this is the second round of litigation, my lord.
See on that, on 19th March.
Please,
For which date all office objections in the
Please.
writ appeal shall be removed.
Please, great.
Much obliged.
This is 230 matter, seal number 86. So withdrawal of contempt, Ramit Yamagde.
86. Withdrawing,
Please. Parties are not interested.
figures on record of the present contempt petition, memo dated 4/2/25, in which the complainant has stated that they are not interested to continue with the present contempt petition. The memo is signed by the complainant number 1 as well as complainant 2, and is also signed by the learned advocate for the complainants. In view of the memo, dismissed as withdrawn.
Please.
In view of the memo, the petition is dismissed.
This is seal number 87. Lordships.
Writ appeal is dismissed.
Great. This is seal number 88.
Here for the petitioner. This is the matter relating to the Preservation of Trees Act. Now, there are three IAs that fall for consideration. The first one is regarding the command hospital. This is IA 2 of 25.
आपने दिया, जोन में दिया, say it.
IA 2 of 20.
ये तो है इसमें. So IA number 5.
IA number 2, my lords, is in relation to Command Hospital.
That is by you.
No, my lords, that is filed by,
IA number 2 is filed by you.
IA number 2 was filed by me asking for a stay. 538
There
trees
we
were.
have passed the order. Please.
Plus in this, the only main objection we had raised was that the technical committee report was not available. They have served that to us today. My only request is that the BBMP may be directed subsequently to upload it to their website in accordance with the directions of this honorable court.
I've instructed so, madam, they'll be uploading it.
They have said they will do so. The other request I had made, but they have said it's not possible, is that the compensatory plantation is happening about 12 to 20 kilometers away. I had requested if there is a feasible way for a portion of the plants to be, a plantation to be done in the same location, but they say it is not technically feasible.
The request of my learned friend, this, my lord, we have already planted about 5,380 plants in the afforestation plan scheme, my lord. Now my learned friend is asking to plant some more trees in Bangalore, my lord, because he says, my lord, the distance where we have planted is more than 15 kilometers. Absolutely, it may not be right, my lord. The reason is this, my lord. Yalanka is just about 8 kilometers or 9 kilometers from here, my lord, within the BBMP limits. This is my first submission. And so far as the second submission is concerned, my lord, there are no Air Force land in Bangalore, inside Bangalore, my lord. Therefore, my lord, my learned friend has agreed if it is not there, my lord, post facto also it can be done is what my learned friend is told, my lord. The two applications which have been filed is, my lord, one is to recall the order, my lord, IA number 2, and one is for impleading, my lord.
Insofar as this IA is concerned, we are not pressing it because they are in compliance. They appear to be in compliance with the directions of this court. This IA 2, my lords. My lords, an order has been granted in my favor. They have now shown compliance. Therefore, the OM may kindly be allowed in accordance with. In fact, the Honorable Supreme Court in similar circumstances has recently passed directions that when trees are allowed to be cut, the compensatory aforestation should be done in advance.
Yeah.
Which is what they have done.
Where is 5? IA 5. This is 5. No, this. Which is the application by this command hospital?
Please, my lord, it's one is IA for impleading and one is for recalling. IA number 3.
Not impleaded. IA is granted or not granted?
Not granted, not there.
That's IA number 5 is for impleading, which your lordships allowed on the last occasion. And we've carried out that impleading also.
Please.
IA number 6 has been filed for recalling the order.
So write down in IA 5 of 5 is for impleading.
Impleading.
That's on the last occasion, your lordships directed us to implead them and we have carried out.
By
the-
virtue of order dated 6/2/25 passed in the main writ petition number 1784/1 of 2018, the prayer in this interim application stands granted. Accordingly, the interim application number 5 of 25 stands disposed of. So this is our IS 6 is for recalling all. So IS 6 is for recalling
Please.
of
Order in IA 2, my lords.
22/1/25. That is passed in IA 2 of.
Please,
Please.
please.
That's correct. Where is IA 2? No, IA 2. This one. Yeah, आपका system I am not take IA 2. So you are not pressing IA 2 in view of what is stated in IA 4?
Please.
IA 4 or what?
No, my lords, in view of what is stated in IA 6.
IA 6. So in both will pass common order.
Please.
Please.
IA 6 and IA 2.
The BBMP has today filed that expert committee's report. My only request is that they may be directed to upload it on their website.
This compensatory plantation is done where? Away from the hospital site.
Please. It is done in Yalanka and Jalalim.
Is stated by you.
Please, my lord, state it. My affidavit, my lord. Para 6 minutes.
Within municipal limits.
Please, ma'am.
At two
Please.
designated air forest establishment, air forest is in Yelahanka and Jalal.
Please. Along with the photographs also, my lord, page, starts from page 1. Last, my lord, 126 onwards.
What is this office memorandum?
Office memorandum is the permission given for us, my lord, by the BBMP.
Battery officer. Battery officer?
Yes, my lord, yes. My lord. Based on the report of the tree expert committee.
Correct.
Please.
So how many trees you are going to cut?
My lord,
538 trees. my lords.
if your lordship may kindly turn to page 11 of my affidavit, my lord.
You tell us the number.
Please, my lord, 211 we are going to retain, my lord.
Cut.
Cut is, my lord, 530, my lord.
513.
Please, my lord. 530. 30.
And 8 trees are being translocated.
8 are translocated.
Please.
So we'll be replanting 530.
5,300.
You've already planted, my lord, 5,380.
No, you are cutting how much?
530, my lord.
530.
Please.
And
10 trees per tree that is being felled.
10 trees.
1 is to 10.
10 trees per felled
That
tree.
is in some of the order passed in this.
Please,
month.
Lords.
Yes. All right, we'll pass the order.
Please, Lords.
Please.
Common order in both. 2 will be disposed of
Okay.
and 6 will be allowed.
Please.
That's
IA number 4.
insofar as IA number 4 is concerned, this has been filed by the RIDCL for felling of about 2,200 trees.
IA number 184.
1988. We are planting 20.
Permission was sought. Sorry, permission was sought for 2,277 and permission has been granted for 1,988.
All are over.
Not allowed.
On this IA, I have served them my objection statement. I may be kindly permitted to. I was served with it last.
Objections are more in them for the, I don't think they are serious objections.
No, the only, they seem to have followed the rules as set out by this honorable court. The only point of deep concern is that out of the 1,900 trees, more than 500 trees have already been felled. They have been felled without permission, without application to the tree officer, in complete violation of the orders of this honorable court. They have already been felled. The tree officer notes this in his order, and instead of taking action against the unauthorized felling, he just takes it as a fait accompli and says, anyway, 500 trees have been felled and we should fell the rest. He is obligated under the act to protect each of these trees. And upon finding out that a tree has been felled, he has to take action against whoever has felled it. It's in complete violation of Section 8 of the Act, and penalties are imposed. It's a criminal offense to fell a tree without permission. He simply notes 500 trees are felled and moves on. Does not take any action, does not even show any concern about this. He just takes it as a fact and carries on.
Not, the question is, my lords, we have not felled the trees. His case is, my lords,
Which is your application?
IA number 4. my lords. IA number 4.
There was no compound walls. Earlier in this K-ride also some.
Yes.
Please,
ma'am.
K-ride only.
Order was passed.
The orders passed allowing,
Earlier, right?
yes, that was allowed.
Earlier
That was an
application
earlier project. This is a different project for which they want to fell 1,900 trees, out of which 500 are already felled
My lord,
in
this-
gross violation of the act. So I don't know whether it is K-Ride who has felled it or some other person. It's not forthcoming, and the officer has not made any inquiry at all as to how 500 trees have been felled and how it has been done without his knowledge. He has an obligation to check every tree and ensure that they're surviving.
You have stated in the reply.
I've put that in my objections. In their application itself, he says it. In the official memorandum, he says trees have fallen. Your
It's a
lordship may-
question of fact, my lords. We have stated what has happened. Somebody has felled the trees. We'll take action against the felling of the trees.
No, even that is not stated that they will take action. He simply says that it has been felled and therefore it is done.
My lords, the question is.
Kindly see page 11 of their application, ma'am. The official memorandum is at page 11. The last sentence. Tree officer in his letter dated so-and-so had asked KRAD to give proper justification. KRAD authorities have stated in their letter dated so-and-so that 226 trees out of the enumerated 2,300 trees have been felled by Southwestern Railway authorities for regular maintenance. Hence, public issue notice has been issued for the remaining trees.
To clarify my learned friend here, my lords, we are not Southwestern Railway authorities. We are for K-Ride, my lords. So therefore, my lords, the fact that we have cut is not correct. It has been, my instructions is FIR has already been filed by the Southwest Railway authorities against the illegal felling. We have come before your lordship to take permission to fell. And insofar as the illegal felling of 226 trees, we are planting those trees also 1:10.
I'm sorry if I was not clear, but I very specifically said I'm not accusing K-Ride of having felled these trees. We do not know who has felled it. My only submission is that the tree officer has to take this seriously and take
We'll do it, whatever request from.
No, where is that fact but stated?
Your lordship would see page 11 of their application is the OM.
Yes.
The last sentence, tree officer in his letter dated 1/8.
One second, court is not able to.
So sorry.
Court is page 11, last 2 lines.
Last 2-3 lines.
His letter dated 1/8/23 had asked KRAD to
Correct.
give proper justification.
K-Ride authorities have stated in their letter that 226 trees out of the enumerated 2,364 have been felled by Southwestern Railway authorities for regular railway maintenance work. Then your lordship may see in the TEC report also, an additional 290 trees are mentioned to have been felled. That your lordship will see at page 222 of this IA. There's a table and serial number 6 there.
And 6.
And it is 558.
In addition, at page 222, my lords.
Then the explanation of the KRAD is considered.
Considered, my lords.
Thereafter this order is passed.
Please, my lords.
As
And
action
what,
must be
in fact,
taken.
we brought it to the notice of the tree committee, somebody has felt it. That is, in fact, my lord, this is information given by us, saying that this is what has happened. Insofar as those trees which have been cut illegally, we will plant it. It's our inspection, my lord. Originally, your lordship, can you take page 322, my lords?
Please, Mr.
Page
222, my lords. On serial number 1, my lords, what we found out was total number of trees as per the enumerated in the list of K-Ride was 2364. Subsequently, we saw that serial number 2 inspection, serial number 2, trees which have already been felled at the time of cursory inspection was 226. Then, my lords, 226.
Then serial number 6.
Then, my lords, as my learned friend pointed out, serial number 6, subsequent inspection we found out 302 was also illegally cut. So total illegally cut is 528. This was considered, my lord, and we are planting 1:10 insofar as this 528 trees also. We have done thorough inspection tree by trees, brought it to the notice tree felling authority and the expert committee, my lords. And this is as against, my lord, 23,000, 2,364. tree expert committee looks into it, examines it, and then the report is given, my lords. It's like saying, well, somebody has committed an offense, we will not permit you to go ahead with this project.
Just want to once again clarify that I said I don't have
No,
objections to the project. The project can continue. All I'm requesting is that the tree officer be directed to look into this
We'll
matter
do
and
definitely.
take action.
We have no, we are not against that. Let them do
That's all,
that.
that's my only request.
In fact, the FIR has been lodged. We'll ask the state also to, the state will also look into those aspects, my lords. But
It's only on the face of the report, it does not reflect that he is doing anything about
no,
it.
any
That's all.
direction from your lordship.
The request was that he should take action.
We'll take action. I mean, we'll see that action is taken against that illegal felling. Your lordship may direct that also, my lord. We have no objection on that. In fact, FIR also has been filed on that, my lord. Let your lordship may direct that early investigation on the FIR be against whoever has illegally cut the trees, my lord. That's all my learned friend wants. And this is on railway property, my lords. FIR is filed, my lords.
Yes, right there.
Well, as per the after, we have entered into an MOU with the Bangalore Development Authority as well as BBMP. Place has been earmarked to plant the trees, 1:10, and the amount also has been deposited, amount towards this. I mean, ultimately, we give the amount, the area, they do BBMP and BDA under the MOU, they implement the thing, that we have produced it, your lordship may kindly take my application file for permission, that your lordships will get it at document number page 536. 536. The memorandum of understanding entered in with the Bangalore Development Authority and with 568 with the Bangalore BBMP. Two agreements we have entered to implement compensatory afforestation of this 28,000 trees. I'm instructed that compensatory afforestation usually is done in May and June during monsoon period. We keep it ready so that your lordship, page 536 and 570. No. 568. I'm sorry, 541, my lords. 541. Just is a 541, 541, 541, R5, given by care applicant herein to Deputy Conservator of Forest, both Bangalore, Mahanagara Palike, compulsory afforestation. Your Lordship may kindly turn to next page, my lord, 542. 7 crores 58 lakhs 4,120. Totally, my lords, it comes up to 12 crores 43 lakhs 20,000 has been already been paid, my lords. And page 543 is a tender called for, my lords. Page 543 maybe, 544 may be kindly seen, my lords.
AG,
Sorry, my lord.
at 568.
568, please, my lord. I'll just 568.
You intend to plant the trees in the lake, is it? So closing the lakes.
No, surrounding, my lord, not in the lake, surrounding the lake.
But you can't close.
No, no,
Not
no.
as an effect of
No,
closing
no,
the lake.
no. Question does not arise at all, my lords.
Because you identified all the 6 places, they are lakes.
No, BBMP identified, my lord. Well, I understand, because the way it is written looks like a lake is being converted.
Are going to be covered. Huh?
No. It's in the buffer zone, my lords. Yeah. The surrounding the lakes, my lord, not on the lake. In fact, my lord, can I request page 544 for a moment, my lord? No. Indication surrounding, because they are well maintained surrounding the lakes, my lord, it is protected also, my lord. It doesn't say surrounding, as my learned friend.
In the buffer zone, you want to.
In the buffer zone, my lord, in the buffer zone. In fact, next time. Your Lordship may kindly page 544 for a moment, my lords.
According to you, 528, these are illegal.
Not by us. Yes, my lords. 528 was without permission, my lords. We inspected initially, my lords. The numbers was correct. When we went for re-inspection, first time 203 came less. 226 came less. We pointed out that 226 from what we inspected initially. Then tree committee inspected, my lord, they found another 302 less. Therefore, as time passed by, my lord, illegal felling was going on. IF4. Please.
Only 4. I have not filed, I've filed objections to their IA. I didn't file a separate IA. Only objections.
That leaves IA number 8, my lord. IA number 8, that is the one, my lord, for BMRCL. No, my lord, that seems to be the most important. Yes. Day after, my lord. Wait. But it's ultimately similar, my lord.
Please.
Thank. Yes. Can it be on Thursday, my lord? Instead of Thursday, 13th. Wednesday, my lord. Instead of 12th, can I have it on 13th? Thursday. At 2:30. Great.
Obligements.
I'm sorry?
First half. Yeah.
If it's.
Please,
wait, first.
As my lords were mentioning about lakes, my lords, there's other matter pertaining to lakes. Whenever convenient, your lordship will kindly. Yeah, I leave it to your lordship whenever, please. Grateful to.
Grateful much.
Kindly may grant 1 week time, my lord. Kindly may grant 1 week time, my lord. Kindly may grant 1 week time, my 89, serial number 89. My file is misplaced in my office, Your Honor. Much.
Till number 90. Sridhar NG. Assistant Commissioner after lapse of 57 years from the date of the ailment. Already, even though, already your lordship, even though there is a violation of section 4(2) of the act. Already, first respondent procedure, malad, the settled position for position and malad, the transaction is settled. But this more that cannot be disturbed. After lapse of 27 years. From the date of coming into force of the act, 37 years. Moreover, the land was granted at upset price. Upset price with a non-alienable condition of 15 years.
Two to four, my lord. 2 to 4, respondent number 24.
Rajendra is for first respondent. Manjunath. DM Manjunath. Who is the purchaser?
Obliged.
So number 91. So Sampath.
Lords, this matter, my lord, the grantee's appeal. Lords, the delay is of 10 years, my lord, on the two grounds the honorable single judge, the petition of the respondent purchasers was allowed. Lord, the two grounds, my lord, on which the learned single judge allowed the purchasers petition, my lord, the sale it was upheld. Lord, delays of the year 10 years, my lord. And Lord, second contention is that, my lord, the property is purchased in a auction under upset price. My lord, it's my contention that my lord, grant was, since my lord, the petitioners belong to the privileged community, my lord, the grant is no, though in auction, but it is not an upset price, my lord. The grant lordships find at annexure page 4040 is a translated document, my lord. The grant is of not an upset price, my lord. It's on a free of cost.
My lord, the land has been granted for an upset price, my lord, annexure A, my lord. In page number 40, my lord. My lord, page number 40. May I read, my lord? My lord, line, in page number 40, line 10 or 12, the entire government suitable value has been remitted to the Amaldar of Chikbalapur Taluk in terms of RD dated as per Tahsildar's order, my lord. They have remitted the upset price, my lord, to the government. The land has been granted for an upset price, my lord. And there is a delay of more than 10 years in this matter, my lord. The Honorable Single Judge has followed the
Let's 18, 13. Let's two submissions, please, my lord. Thank you. Let's one submission, my lord. There's a 12 lines in the same annexure, page 40. My lord, it's on free of cost, my lord. Please.
Take any standpoint.
Please, my lord.
Take any standpoint.
Please, my lord.
There is no merit.
No, my lord, sir, I have learned two contentions, my lord. I'll submit, my lord, this annexure grant, my lord, there's a clear mention. My lord, 12 lines, my lord, lordship may kindly note, my lord. It says, my lord, I just read it. Chikka Gangappa has remitted the entire government cost to the government treasurer freely, the entire government
Then
suitable.
if you are right on that count, then 10 years delay.
My lord, that for the 10 years, my lord, I just submit one decision, my lord, wherein the learned single judge of this honorable court side, my lord, 11 years delay is also, my lord, not so. My lord, may just tender, my lord.
There are a lot of judgment.
No, my lord, that is
in the division bench of Dharwad, then followed by us in series of judgments.
I'll just tender, my lord, but that is also in under appeal before this honorable court, my lord. There is an order of status quo. In a coordinate bench matter, my lord, may just tender that decision, my lord. Let's page 12, last portion, my lord, para 13. My lord, the following the decision of Satyan, my lord, the dishonorable Clarence Single Judge of dishonorable court said that, my lord, may just read the para 13, my lord. In that view of the matter and in the light of the observation made by the Honorable Supreme Court in the case of Satyan Supra, these courts proceed to hold that delay of nearly 11 years cannot be held to be such that the application was required to be dismissed on the ground of delay and latches. For the aforesaid reason, since it has been held that the application could not have been rejected on the ground of delay and latches, the sole contention raised by the petitioner is answered accordingly. Lord, this is under appeal before this honorable court, my lord. It is still pending consideration. Writ appeal 300 of 2021. My lord, on 28/1/2025, my lord, the honorable coordinate bench, my lord, granted an order of status quo. No, my lord, this needs to be, my lord.
This judgment may not have even persuasive value.
Lord,
Firstly, it is a learned single judge.
please, my lord.
Even if you cite as a persuasive value, normally it is not cited before the division bench. Even if we see to it, there are several division bench judgment taking a different view.
Please, my lord.
Wrong judgment, so
Lord,
dismissed.
That's my only submission, my lord. If this writ appeal which is pending consideration on this count, my lord, is considered. That's
Sorry, dismissed.
Who are you?
my lord, Sam, the grant is legal here, my lord. Original grant is, my lord, the legal here, my lord.
Original grant is legal.
Legal here, please.
Number 92, to Onkar KB.
Be permitted to withdraw the appeal.
Learned advocate, Mr. Onkara,
Please.
KB, files memo dated so and so, so and so. Dated 10/10/10/2/25, which is taken on record. In that memo of withdrawal, permission is prayed for withdrawal of the appeal. Permission is granted in view of the memo. Petition is dismissed as, appeal is dismissed as withdrawn.
Yes. Seal number 93. Mr. Ravi Shankar Shastri.
Complainant, my lord. Lord, there was a direction, my lord, to comply with the order, my lord, within 3 months, my lord, in the writ proceeding rules, my lord. The order was dated 24/8/2023, my lord. 3 months time was granted to the accused, my lord, to issue 11E sketch, my lord, in favor of the complainant.
There was a liberty reserved by the learned single judge, my lords, to comply.
Have you seen the earlier order?
Please, my lords, I've seen, my lords.
So
So thereafter, my lords, after the subsequent to passing of the orders last time, my lords, there was a liberty reserved in the writ petition, my lords, seeking for extension of time, my lords. The matter was supposed to be with the honorable court on 3/2/2025, my lords. The learned single judge has given 6 weeks time, my lords. Within 6 weeks, we'll comply. That is well within the knowledge of the petitioner also, my lords.
No,
Matter was listed there. That, within 6 weeks, we will issue the 711 sketch, my lords. Almost the work is done, my lords. Further time has been sought. Process itself will be completed before 6 weeks, my lords.
they will do within 6 weeks now.
This we will do it, my lord.
They
That's
should
short.
have-
When the
my lord, they should have sought time, my lord, extension immediate for 3 months from the extension of time, my lord. Not after my lord says, passed an order, my lord.
Paragraph 5 and 6
Now, may I seek, my lord, one indulgence? Could it be called after 6 weeks, my lord,
of
contempt?
order dated 24th August 23 of learned single judge. reads as under paragraph after quoting, paragraph 10 is. In the contempt petition, which was filed for non-compliance of the above direction, today it was pointed out in course of the hearing by Learned's advocate Mr. So and so respondent that as per the liberty reserved in paragraph 6 of the order, the respondent had approached Learned single judge with prayer for extension of time. Full stop. By order dated 3/2/25, Learned single judge has granted 6 weeks time to comply with granted extension for 6 weeks for compliance of the directions in paragraph 5, afore quoted. In that view, the contempt petition does not survive. The competent authority, the respondent authority concerned shall comply with the direction within the extended time. Failing which,
Please.
a fresh cause of action will arise to file a contempt petition.
Liberty to revive, my lord, if they have not complied with me.
With the bola, but that is what we have said.
Please, ma'am.
Fresh petition, not revive.
Please.
It's number 94, Shreyan Sriram Reddy.
That's, we have almost complied, my lords. The assistant commissioner has made the order, but has not affixed the signature. She's on leave, my lords, because there's a death in her family. 4 days time may be granted, my lords.
It was stated
Almost
that the
complied.
compliance is in process due to personal compulsion of the officer, personal disablement, personal cause which disabled the officer to take the compliance to its logical end. From a time may be granted, stand over to 20th, 24th, 28th February
Pledge.
to be listed at 2:30.
It's number 95, T. Sheshagiri Rao.
I think the contempt will not survive minutes after the last date. A notification has been issued minutes by the authorities that they'll hold elections.
Date is fixed, my lords. Elections will be held on 25th May, my lords.
That should serve my purpose.
Calendar of events has to be published, that's all, my lords. The election date is fixed, my lords.
Comply with.
Please, my lords. On last date, my lords, the lordship had passed an order to ask when the elections will be held by the authorities, my lords. Pursuant to the same, the deputy commissioner has issued a notification that elections will be held on 25/5/2025, my lords. It will not survive, my lords.
You withdrawing?
I think they'll adhere once your lordship has said.
Learned additional government advocate, Mr. Raghavendra produces copy of notification dated 4/2/25. Copy of which is also given to learned advocate, Mr. So and so for the complainant. First of, in view of the above notification, the contempt petition does not survive.
Please, my lords.
As stated by the counsels of the parties, it is accordingly disposed of. Does
Please.
not survive.
Oblige, my lords.
Notification dated 4/2/25 shall remain on record.
So 96, Agent, seal number 97. Basuraj Karedi.
My lord, I am appearing for respondent number 3, Kuda, Kalburgi Urban Development Authority. I have already filed my statement of objections, my lord.
My lord, in this matter, the short question for consideration was whether CA sites reserved for earmarked for specific purpose can be allotted to some other purpose which already has been so done. On the last date of occasion, my lords had heard me, and it was for the respondent number 3, Kuda, to answer about whether those sites are earmarked for that specific purpose, my lord.
In the development plan.
Please, my lords. My lords, if I may draw my lord's attention.
Same that post office and.
Please, my lords. Post office, dispensary and primary school. My lords, if I.
Yes, so now what to be done?
My lords, If I can point out from the statement of objections filed by Kuda, my lords, page number 1. By respondent number 3, statement objections by R3, my lords. Date 1/7/2024, they filed, my lords.
On 7/23.
2024, my lords.
My lord, I'm sorry to interrupt, my lord. The corporation also has to say in this matter, my lord. We are, my lord, allotted these sites. Admittedly, the layout was approved in the year 1999. My lord, this society, the petitioner society was registered as a society in 2023. These sites are allotted in, my lord, 2020. My lord, here as per the, my lord, the request of the government, these sites are allotted. Therefore, the corporation also, my lord, respond, my lord. Their stand. As per the, my lord, government decision and the, my lord, the payment, 50% payment by the government, we have, my lord, allotted these sites to the Samudaya Bhavana. As per the civic community site, Samudaya Bhavana is also comes under the definition of civic community site. My lord, here, this society, my lord, though it was approved in 1999, admittedly, they were reserved for the post office, the dispensary, and school. My lord, nobody has come forward for the allotment of the sites for the purpose that they are reserved. My lord, in the year 2005, one Sahara Education Trust has filed the application and the site was allotted. Because of non-payment of the total consideration amount, that was cancelled in 2019. This is the, my lord, factual aspects. Because the CS sites are, these sites are situated in the heart of the city. My lord, the encroachers, the land grabbers problem was also there. Because of the government request, the code has granted. And the construction was made and almost the building was completed. From 2020, they are constructing this petitioner society registered in 23. After registering as a society, they have filed the representation and it was answered. And thereafter, they filed this PI writ petition, my lord. Therefore, my request, the corporation is also required to be, my lord, responded.
Now the property comes under the jurisdiction of what?
My lord, now within the corporation limit, the CUDA after allotment, my lord, they will construct the, my lord, the purpose for which it was.
No, the layout has been now handed over to city corporation, is it?
My lord, CA sites, my lord, except
Mr.
CA sites layout.
Now the layout,
my lord,
has it been handed over to city corporation now?
that I have to ascertain, my lord, insofar as CA sites out, till the allotment of the CA sites, they are under the possession of the CUDA.
CSIT. You are making a submission that corporation is a just and necessary party.
Yes, they are
We
the
have to
respondent.
include city corporation as a party to the proceedings. Then if you say they are just and necessary party, we are required to know under whose jurisdiction the property situated comes under.
My lord, for that, my lord, I seek, my lord.
Then why did you make a submission that corporation is a just and necessary party?
My lord, it is a party respondent number 4.
R4 is corporation.
No, he just made a submission, right?
Yes, my lord.
Yes.
Commissioner City Corporation, respondent number 4. And they are represented by a council.
Whom do you represent? Now, you are required to show in law when in your plan you specify, in the approved plan you specify that the land is reserved for a particular purpose.
Please, my lord.
Without anything, you can use it for some other purpose. You are required to show it.
Please, Lord, I will show, my lord, only civic community purposes, the purpose for which it was reserved, if it is not utilized for that particular civil amenity purpose, it can be utilized for other civic amenity purpose.
Now, the approved plan shows that it was reserved for some other purposes. In civic
Yes, my
community
lord.
itself,
Post office, post
that it was
office,
specifically reserved for post office and other two purposes.
yes, my lord, yes. my
Now,
lord.
if you want to divert it, the
The
question
post
is it
office,
permissible in law to utilize it for other civic community purposes? Show it.
my lord, I will, my lord, on the next date of hearing, I will submit, my lord.
What is this
On the-
counsel? That is the fundamental thing that you are required to prepare it and come.
This post office.
Since
And for the including applicant, is objective.
Yes, madam, what do you?
Lord, we have given the site as per section 3 for the purpose of Samudaya Bhavan. We have asked them to deposit the amount. We have been empowered under the
See, if you had said in the approved map
yes.
as a civic community site, you could have used it for any of the civic community sites. Now, when you say it is specifically for post office, dispensary and school,
Yes.
the question that arises for consideration is, can you utilize for some other civic community purposes?
Yes.
Okay. So in law, show it that that can be utilized like that.
My lord, please see Rule 3 of the Karnataka Urban Development Authority, my lord, allotment of civic amenity site rules 1991.
Rule 4,
Rule 3.
rule 4,
Rule 3, my lord,
3. 3,
3-1.
3, 1.
If I may, my lord.
What is rule 4?
My lord, I can only take shelter under Rule 3, my lord.
You can
which
take
is-
shelter under rule 3 provided rule 4 was not there. When rule 4 is existing, how do you interpret it? You will have to say.
Very well. I will distinguish that.
So this allotment is under rule 4 or 3?
Rule 3(1). My lord, because it says that, my lord,
Sites reserved for subgroup one of which maybe the category specified there. These are categories that they have made. See, no one is going to look at it.
Which is the category specified under 3(1)?
my lord, this is for, my lord,
This 2B is the category.
My lord, in fact,
What is the procedure for doing? It is featured in 24/7. The resolution gets filed in 2020. Are photographs or anything are produced showing the status of the building?
my lords. My lords, an
Constructed.
impleading application has been filed in which photographs are produced, my lords. 13/8/2024, impleading application filed by the private party. In fact, this site, my lords, is allotted to a private.
Letter of allotment? When was it allotted? Any letter of allotment produced?
My lord, annexure B, page number 25 is the order of the DC, my lords, directing the Urban Development Authority to page number 25.
It was in 2020.
2020.
How do you explain the delay of 3 years?
My lord, we got to know about once they started construction only. Lease deed, my lords. Lease deed is of the year 2021. And thereafter only we got to know that they started constructing. We had in fact filed an earlier PIL, my lord.
When did you come into existence?
My lord, we came into existence in 2023, my lords, if I'm not mistaken. My lords, page number 39 is my earlier PIL that I had already filed, which was disposed of, directing me to give a representation to the other side because earlier I had not given a representation. So I gave a representation in 2023, for which they replied stating that it is a CA site and it is permitted under the Town Planning Act, not even the Urban Development Authority Act. In fact, my submission is, my lord, this is not a CA site as per the definition of civic amenity as per the Urban Development Authority Act.
Then what is it?
It is, they claim that it is, if my lords have section 2H of the Act, my lords.
What is civic amenity? Useful to a community.
Please,
It is
my
also useful to a community.
My lord, it is a recreation. This,
Samudaya Bhavan.
it is for a particular community, my lord. It is not a general recreational center. It is for Bhovi community. In fact, their impleading application also states it is for the benefit of Bhovi Samudaya only.
my lord,
Their
ma'am,
impleading application, if my lords have, my lords.
You come under SC/ST? Community comes under SC.
yes,
SC, ST category. 18% has to be reserved for them, no?
Yes.
My lord, my first line of argument is that admittedly, it is earmarked for those three specific purposes and it cannot be used for any other purpose.
Show it in law then. You can't just rely on one piece of plan which is sanctioned and argue like this. Show it in the rules and regulations that a site allocated to a particular civic community purpose has to be utilized for that purpose only and not for other purposes. Nobody is willing to show it. None of the councils are prepared.
My lord, my lord, my instructions are the central government has not come forward, my lord, for opening of a post office in that civic community site.
That is not, that's,
My lord, can I just look into the records and make my submissions? My draft is ready, but the officials are not cooperating.
My lords, I had given a judgment of the Supreme Court on the last.
first show in the statute book, madam.
My lord, section 39 of the Act itself,
Yeah.
my lords. Section 39, my lords. Prohibition of use of area reserved for parks, playgrounds, and civic amenities for other purposes. The authority shall not sell or otherwise dispose of any area reserved for public parks and playgrounds and civic amenities for any other purpose, and any disposition so.
It does not, see, what it means is reserved for that particular purpose has to be utilized for that particular purpose. That is park, playground, or civic community.
Please, my lords.
Now, here is a case which it is reserved for civic community, but the plan sanction says for a particular civic community. Now it is being changed for another civic community. See, what has been changed into is also a civic community purpose only.
I follow, my lords.
See, when you say that once it is allocated for a particular civic community, it has to be used only for that particular purpose. You have to show it in law how. And then second thing is you have to overcome delay and latches. Because you yourself come into existence in the year 2023, and how you can challenge something that has happened in the year 2020.
My lord, because we were never even aware that the building was coming up and it was allotted this way, my lords. There was no public notification or anything. We were established and they started constructing. Immediately we filed the first PIL. So as such, there is no delay per se, my lords.
You find out what transpired in the background. Something must be on the record. Your
Yes,
record.
yes, ma'am.
Some correspondence, some reason.
I'll do that. ma'am.
And there is a delay also on your part.
My lord, my humble submission is there is no delay, because how will I get to know that the government has allotted to somebody unless they start constructing in those civic community sites? I am a resident of the locality. I see it and I immediately file my PIL.
Very well, we'll see. Just look into it.
Yes, madam.
Produce some record and that will
Yes,
help substantiating your case.
obliged, madam.
And legal issues have to be addressed.
When shall we keep?
My lord, 2 weeks, my lord. Kalburgi.
2 weeks will be somewhere in March, 14th March.
No, my lord may have this, my lord, tentatively on the 27th, because at least I can apprise my lord and then thereafter take some time. if need
27th?
be. February. In case if I need time, then I'll make a request to my lord. I don't want it to be a long gap.
Then 4th March.
Obliged.
Obliged. 2:30, my lord. At 2:30. Very good.
Bill number 98, Mr. Nityananda Murthy P.
Nobody is there. Party in person?
No, my lord.
This PI,
No. Not a writ petition, my lord.
interim order is also operate.
They were operating pursuant to an interim order, my lord. There was a penalty order. Penalty amount has been remitted as a condition for operation.
The record of the order sheet shows that the petition has not only been adjourned from time to time, even as the time to time, learned advocate for the petitioner has remained absent. On 5/2/25, the court had an occasion to pass this order, import the order. Full stop. The absence of learned advocate petitioner continues on one hand, and on the other hand, interim order is operating, is operating in favor of the petitioner. Today also, learned advocate was not present when the petition was called out. Also in the second part, the court has no option but to dismiss the petition for want of prosecution. Petitions.
Number 59. The Vardhaman B. Gunja.
Spite of my lord, some office objects all are complied, my lord. I sought for dispensation of certain annexures. In fact, I have not sought for quashing them at all. That page 33 is the prayer, my lords. 32 is the prayer. Not sort of quashing of those annexures. I am relying on them because their public document shows the suit property, the petition property is a public property on which the fourth respondent is construction, my lord. The pendency of the proceedings, my lord, on earlier occasion, this on Report 17/8/21, notice that was illegal construction, respondents corporation made a submission. Thereafter, my lords, the construction has been up in spite of at their own risk. Now, my lord, matter expects to be heard. It's being built next to a stormwater drain where the vacant land was reserved for cleaning the stormwater drain. That has been occupied.
I represent respondent number 4, my lord. Totally a different property, my lord. In fact, they in their schedule would show on the western side my property. Western boundary. My father's name is shown there. Property which was earmarked by the BBMP is different and the property in which where I am residing. I am presently residing there. By virtue of registered sale deed of the year 1964, I am residing there. In fact, what I did was an old construction was there. It was an asbestos sheet. I wanted to construct it as a RCC construction at that point of time. This is. In fact, BBMP has also recognized my been paying taxes to the BBMP. Mine is 30 into 45 feet.
You are private respondent.
Okay, sir, respondent number 4, man.
4.
4.
So it's
And the
one-
statement of objections also, where I have stated that I am.
you are in possession of this 138,
Please, my lord.
plot number 138.
138 doesn't belong to me. I am not constructing anything on that also. In fact,
Please, my lord,
this schedule.
there's already a report from the BBMP that construction is already going on the public property, my lords.
Belongs to
Finding
who?
out, BBMP was direct to file objections. They are not filed objections, my lord. That is a difficulty. 3 times they have taken, and the BBMP advocate is retired. I will take, if a new advocate is to be there, my lord, I will take notice on the BBMP. It may be heard, my lord. I'll demonstrate it's on the public property. Now, the difficulty is that BBMP advocate is retired. They have not produced the records.
They have not.
counsel was representing BB.
Records have
is
not
no
been
more.
produced,
He has retired. New advocate has to.
You has not come.
He has not come.
It was stated at the bar that learned advocate who represented this number 1 and 2, 1, 2 and 3. The Bangalore Mahanagarpalika, Brihad Bangalore Mahanagarpalika has retired,
No, he has filed a memo of retirement from the case, my lord.
has filed memo. of
Are
retirement.
1, 2, 3 advocate filed?
In that view, there shall be press notice to the said respondents intimating about the retirement memo and in order to, and to enable the said respondents to make alternative arrangement. The notice in this regard shall be made returnable on 13th March.
Number 60. The Durgekar Sujat.
My lord, I appear for respondent number 3 in this case, my lord.
My lord, I have two submissions, my, the PL which is filed in 2022. We never had a hearing, at least or 2 hearing, because it has been listed in general category, we come sit and go. And I met judicial and the board OS, they say lordship should give instruction to them, my lord, to file it in a PIL list. And another one is, the respondents have not bothered to file any objections till date, my lord, all of them collectively.
You got one submission, my lord. I appear for the respondent number 3.
SLP is what, pending?
Yes, my lord, it was in Delhi. The verbal instruction was not to commence the work.
What
That was related to something else, but this I'm challenging the CFE which was given subsequent to that.
No, in the last order, the court has said that SLP is filed against.
Yeah, CJ had directed the respondents to update the status of the SLP in Delhi. But till now, they have not filed anything on that, my lord, respondents.
Who will appear here? Here, who will appear?
We appear for respondent number 3. my lord.
Madam was there. This whole project was based on a false information. That is what I'm challenging is CFE, my lord. I had approached the NGT. They said as an appellate, it should be dealt with High Court. They redirected me here. The port as itself now operating illegally, my lord, they don't have any green belt coverage as of now. They don't have firefighting facility as per CCOE
Nobody
requirements.
is there will take up after some time. Ours give some date in this week of 24th March.
So, my lord, to be listed as PIL, my lord, to be listed in PIL list. Obligement.
24th.
Yes. My lord, there was a press meeting held this week that they're going to start the work. So if you give me some restraining order as per the interim. There is interim order pending, my lord.
Only 24.
Obliged, my lord.
Case number 61, Mr. Manjunath LS.
Petition.
P1.
Yes. PIL has.
PIL, my lord. So, at the cost of the BBMP public authorities,
Very good
we
photograph.
have
Page.
displayed the illegal
Page.
MLS photographs.
Photographs are very good.
Photographs at page number 20, 22. Copy.
Xerox copy of good photograph. What is
In
this?
all public playgrounds as well as parks, as well as
Public play-
gymnasium, community halls, everywhere they have displayed at the cost of the BBMP funds, my lord. See, it is again contrary to the decisions of the Honorable Supreme Court as well as this Honorable Court decision. At page number 62, this Honorable Court has passed the order not to display any that illegal photographs. Only elected concerned ministers as well as chief minister, that only allowed.
Ministers are going where?
Kindly come to the para number 15 of the pleadings at page 10, my lord.
Remove the illegal photograph list of electric representative.
Para
That is
15 of the pleadings at page number 10, my lord.
Daya Krishna MLA. Why only two? And M Krishna 5. In BBM beyond PMI.
And
Why only two?
pardon?
Only two you want to remove, all other let it be there.
Oh, there are in many
Ah,
constituencies.
there are how many there? Photographs are?
How many photographs? It's in all public places of the around entire Vidhan Sabha Assembly constituency, both Govindaraja constituency as well as Vijayanagara constituency.
They are
Both MLAs are, son and father is the MLAs representing the constituency.
They are private hoardings or somebody else?
In public properties, my lord. The BBMP buildings, BBMP owned buildings, at the cost of the BBMP funds, they have displayed. That show it is contrary to the Supreme Court decision as well as this Honorable Court decision at page 62, my lord.
Supreme Court decision, page 62.
Page 62. At para 5, man. I think. Para 5 and 6. Page 66, man.
Where is that 60? There is no Supreme Court.
Page 66, sir. Supreme Court decision is not there, but I reproduced it in my pleadings at page 10, my lord. Pleadings at para 15. Page 10.
Yes.
Look, my instructions are all these have been taken down or been covered. I've been produced, I've been given photographs, my lords. I may be allowed to place them on record. The last date of occasion, I was asked to produce this. I have these photographs with me. I'll place them on record with an affidavit. as well, my lords.
My lord, I had photographs in the June as well as in the 26th January of this year,
Where it is?
displaying the same, in the same, all the playgrounds for public BBMP properties. Kindly peruse these photographs. Still, they are showing that only the day of hearing comes, on that day they are covering the white paper. Very next day it is removed. Photograph.
ನಂಗೂ ಕೊಡಿ. ನಂಗೂ ಕೊಡಿ.
That was in June 24th, my lord, as well as these, the recent photographs also I took. Everywhere it is continuing. Father and son is the elected representatives of both the constituencies.
These are photographs of the month of June last year, my lords. I've been given photographs of thereafter.
Also, photograph of,
Date was, their date was
18th
mentioned.
June
particular.
2024 are the dates of the photographs.
photograph of Baba Saheb Ambedkar is also.
Now, recent photographs are given, my lord, 26th January, it's in cover. Gave it in cover.
ನಂಗೂ ಕೊಡಿ. ಹೇಗೆ ಗೊತ್ತಾಗುತ್ತೆ?
Apart from that, they have threatened the petitioner, though he was a resident of that area for the last 20 years. Now he has vacated for their continuous threat, my lord.
Any rules are governing?
My lords,
Any rules are governing for this? Any rules are there? In the
my lords, BBMP has issued circulars.
public places disfigurement rule.
Yes, my lords, that is there.
So this is disfigurement.
My lords,
This is disfigurement.
it can come under that, my lords, but there is notification which are circulars which are issued by the BBMP
No,
commission.
no,
also.
what is your perception? This is disfigurement. You tell you are a public authority, body of local self-government. Photographs on your building of political leaders is public disfigurement, disfigurement of,
I would say, yes, my lords.
disfigurement. I file an affidavit.
I'll do that, my lords.
Learned, I'll say that, learned advocate, Mr. So-and-so, states before the court that he will file an affidavit to the effect that the display of the photographs of the political leaders amounts to disfigurement.
No, no, at least it's against the Supreme Court order. That we may have to comply with. I agree with that. my lord.
Whatever it is,
Yes.
you are saying yes. Then let them file, we'll consider. Any rules are there, you tell us?
Rules aren't there, my lords. After the Supreme Court judgment, BBMP Commissioner has issued circular prohibiting any such activity.
Government
file-
also,
You
I will
file-
place them on record as well.
not
Go-
fi- not-
government also issued orders.
You file something? You file something? You
I haven't filed, I'll be filing it.
File then.
Yes, please.
Response will be
Filed so
filed
far.
within 2 weeks, put up on 21st March,
Grateful, man. 2:30 meter, maybe.
11. At 11. All entire body is at 11, including this matter. Okay, next.
So number 84.
From the last, it is still again.
The other day, my lords, my learned friend, my lords, filed synopsis
and contended that my lords, we have initiated my lords, the proceedings. Matter is with the government. My lords, unfortunately, my lords, what was submitted to this court is partially correct, not fully correct. If lordships kindly have my lords, the what was said was LTR, my lords, is with regard to recovery. LTR actually stands for Local Test Audit Report, which was the report, my lords, which I cited, my lords, when I argued the matter. Not that they have been, my lords, trying to reply. Not the document, my lords, which was cited, my lords, on the other day was, my lords, if lordships have, my lord, 15A, page number 68. They, my lords, said terminal benefits will be paid to the officer once LTR is settled or on obtaining approval of the standing committee of the governing body of ADA, whichever is earlier. Now this settled, if lords kindly take the next document, my lords, what they have produced. Page number 69, my lords. At 70, the last paragraph, my lords, paragraph number 5. LTR settled becomes, my lords,
Page number?
my lords, 70, my lords, it starts at 69.
Yes.
It start, my lords, the officer may be relieved on 31/3/2017 afternoon. However, the dues will be settled after LTR is dropped. They want the LTR to be dropped or standing committee approval is obtained. No, they don't want, my lords, recovery. They want the objections to be dropped or approval of the governing body, whichever is earlier. That is what, my lord, the document, my lord, while relieving the officer, my lord, has said, contrary to, my lord, what was indicated. They said, my lords, we have obtained an opinion, my lords, from the, my lords, the government. If you lords kindly see, my lord, that opinion, page number 71. My lords. This is what they have been contending throughout. If you lords kindly, my lords, the paragraph number 2, in that, my lords, it starts with, my lord, the matter has been examined in this department. Insofar as this department is concerned, my lord, this is by the government. My lord, Department of Personnel. They say this department is concerned, the instructions issued by this department apply to persons re-employed in central civil service and posts. My lord, it is not a central civil service. The instructions relating to pay fixation of re-employed pensioners have been laid down so on, so on. My lords, I'll come to, my lords, starting with these instructions are, my lords, if lordships have, my lords, the fifth line, my lords, from the bottom. These instructions are, however, not directly suo motu applicable to autonomous bodies, educational institutions, PSUs, trusts or banks, etc., which are governed by their own set of rules and regulations, unless they have adopted these instructions. Admittedly, my lord, their case throughout is that we have not adopted it. And what they say, my lords, is this is the instructions we have received. If you lords kindly see, my lords, at the bottom, after this notice, what the, my lords, the joint secretary would say, my lords, is please brief me. Afterwards, my lord, nothing. Their entire stand is that we have not adopted and it will not apply to us. So as my submission insofar as their contention that we have initiated inquiry, we have applied uniformly, my lords, is not correct. And my lords, I'm also entitled for similar treatment, my lords, as done to the other employee. Now, with regard to, my lords, the other appeal, my lords, I showed to your lords, my lords, the manner in which, my lords, I was appointed, my lords. The lords may kindly have, my lords, few documents as to how, my lords, I was treated when I was appointed there. I'll only read, my lords, a few lines, which will make, my lords, clear as to how I was taken in. If your lordships are having, my lords, the first writ appeal, my lords, 1842. I try to notes show to your lordships that, my lords, I have the necessary qualification, my lords, I'm qualified from the flight school, my lords, I have, my lords, continued, my lords, to work. Even I was paid, my lord, the allowances by, my lords, when I was there. Even after redesignation, I was paid. The order says I was working as such. If your lordships kindly come to, my lords, the document, my lords, which I have produced insofar as my appointment is concerned. Your lords may kindly come to mention the page number 271, my lords, annexure L is the, my lords, the order of appointment. In that, my lords, scientist F was notified. There is no dispute. I accepted. I then, my lords, at 273, wrote to, my lords, the my lords, the ADA requesting for, my lords, issuance of no objection, my lords, and requested them to forward so that I'll get the no objection from the Navy. Lords, I'll not touch other documents except, if your lordships kindly see, my lords, annexure Q, my lords. This is as like, my lord, the other candidate. My application was considered, forwarded, and next document recommended by, my lords, the department, and I was, my lords, offered appointment, my lords, annexure T is the order of appointment, and, my lords, I was relieved of, my lords, the naval services. After, my lords, I got the letter. If your lords kindly come to, my lords, the annexure, my lords, X. Annexure W also will read, my lords, page number 290. It remains, my lords, it says, my lords, premature retirement of so and so. Then, my lords, next document. First paragraph itself. The competent authority has approved the premature retirement request of so and so with effect from so and so on grounds of permanent absorption in Aeronautical Development Agency, Bangalore as scientist so and so. Lords, earlier also I was there. It was with an understanding that, my lords, I will work, my lords, in ADA in the charge, my lord, holding the charge of the post, my lord, which was given to me, relieved by Navy, my lords, also on, my lord, the same lines, my lord, no difference between, my lords, myself and the other person who came little earlier, my lords, to me. He, my lords, was in G, my lord, scientist G. I was in, my lord, scientist F. That's all the difference between us. But, my lord, the difficulty is what I said, my lords, is the issue, which was the subject matter of, my lords, me asking for, my lords, the deduction. Now, as I submitted, my lords, the contention of the other side was that, my lords, I did not know, or I was not of, I mean, in fact, in the statement of objection, lords, because, my lord, positive time, lords, I'm just rushing through, my lords. They contended that, my lords, I was only allotted with SPTF work. I was not allotted with any flight test engineer work, which is also not correct. And, my lords, the documents are available. And in fact, my lords, my learned friend on the other day, my lord, said, my lord, some documents is in Russian, and which is difficult to, my lords, the understand. My lords, I share that concern with them, but no, I said that there is some document in Russian, and in fact, my lords, that is, if I'm sorry if I mean, if I not meant that way. My lord, there is an English translation of the document also. My lords, the agency which has issued me the certificate is the, my lord, the government corporation, my lord, which, my lords, manufactures MiG aircraft, my lords, and also assists, my lords, in SBTF facilities. If your lordships kindly come to, my lords, page number 316, my lords. That is 1842, second volume. Uh, 316. This is written to, my lord, the individual who was sitting as my superior and against whom, my lord, I said, I had some grievance. They say, my lord, the third paragraph onwards, know the success, we remember contribution of so-and-so for his energy, devotion, technical and management duties. He was important factor for both countries to coordinate, resolve all technical management issues for early completion of SPTF. He is a true leader and technical management expert. My lord, this is what, my lords, I've been, my lords,
See,
please.
we are not hearing to appreciate how
I'm not on
work
what
you have
part-
done or not.
Please.
See, you are required to show this much.
Yes, ma'am.
Now, you drew your attention to page number 290 and 291 and showed about premature retirement.
Correct.
That means
but-
to say, you are retired from Navy,
Yes. To
you
join.
joined ADA,
Yes, my lords.
okay? And you are entitled to whatever retirement benefits that are available through
Please,
Navy,
please.
number one.
Please.
Number two, after joining ADA, you have to show us, are you entitled for complete retirement benefits from Navy? Or
Please.
the payment made to you in ADA is after deducting the retirement benefits. That you have to show us.
My lord, for that, my submission is, my lord, I stand by, my lord, what I submitted earlier also. I showed the document to your lordships also. That, my lords, the rules are not adopted insofar as ADA is concerned. It's an autonomous organization. Even as per the, my lord, the clarification issued, as such, it will not apply in my case also. As such, they cannot, they maintain double standards, my lords, one standard insofar as an employee, my lords, where there's.
Okay, in your case, they did not, in your case, it was payment minus the retirement benefit.
Yes, whereas in the other case, it was paid.
It was payment plus retirement benefits. That was the discrimination alleged by you. Yes.
My lords, here, my lords, I'm only on, my lords, to show that, my lords, from 2011 to 2014, I was, my lords, according to them, my lords, I was on duties. I'm afraid, my lord, that it is otherwise. Just to show, my lord, from their own documents, my lords, I'm just taking your lords through, my lords. My lords, counted at all. In view of the fact that I was doing some other job, not the FTE duties. And the residency period will count only from 2014. And in 19, my lords, they say I'll be eligible for consideration for the promotion. That is their stand. But my contention, my lords, even before the learned single judge and in the other petition is, I was there, my lords, in ADA from 2008-9. The provisions, my lord, the regulations of ADA says by deputation also I can be there. So as such, my lord, the period of residency, my lords, has to be continued considered from 2008-9, not 11, my lords, as the learned single judge said, and not 15 as the other side is contending now. That is my case. So if it is considered from 8-9, my lords, 5 years I'll be eligible, my lords, in 2014, my lords, for next promotion on redesignation, because I was carrying out the same duties, and further promotion, my lords, as the case may be, was my contention before the learned single judge. And that's what, my lords, I have preferred the appeal also, this, my lord, before the honorable court. In view of the fact that I'm agreed by that portion of the order of the learned single judge. Insofar as, my lords, the other petition is concerned. And my lords, why all these things, my lords, happened, my lords, I made a submission that, my lords, I was sent out of the, my lords, FT duties. They say, my lords, insofar as APAs are concerned, no work assigned, my lords, I said, and they say no 78 marks. If your lordships kindly come to, my lords, 392, my lords, is where I was posted, my lords, out of those duties. 17 September, my lords, I am posted out of the duties. My lords, I retired, my lords, by end of the January, attained superannuation. I was not assigned with, my lords, any official duties, my lords, in the meanwhile, except, my lords, allowed to sign the attendance register, my lords, asked to sign, my lords, the APAS, which I said no duties assigned. Now, my lords, I go back to, my lords, the very same, my lords, the office memorandum which I showed to your lordship on the other day, with regard to, my lords, the interview, my lords. Before going into that, my lords, the first time, my lords, when I asked for, my lords, consideration of my case for promotion, it was not being done. And, my lords, I was issued with an endorsement, my lords, by the ADA, that my case will be considered only when I complete, my lord, the residency period in that is 2019. For that, my lords, they say that see, we will consider only those documents which are your APARs. They don't mention, my lords, anything about the, my lords, the interview marks. Suddenly, this interview, my lord, comes up, my lord, subsequently, my lords, which I have argued. The very same office, my lord, the official memorandum, my lords, issued by the government, also says, my lords, how the APAS to be considered. Admittedly, my lords, I always said, my lords, after 2017-18, that, my lords, I am not assigned with any duties whatsoever. Now, in those circumstances, my lords, my respectful submission is they could not have considered, my lord, those APAS. What was available to them was, my lords, till 2008-9, even according to them, I had scored, my lords, 90 plus. My lords, I'll just take you, lords, through, my lords, the office memorandum, my lords, which is also read upon by them, as per their counter, my lords, before the learned single judge. So, my lords, I read, my lords, one provision to show that, my lords, the interview is not to be held unless it is specifically there in the provision, my lords, which I, my lords, provided to the court on, that is dated 10th April 1989, my lords. There, my lords, part 4, if lords, I'll just take you, lords, the relevant provision. Lords. Operator,
It is in order. Separate.
It has been, my lords, if lordship kindly come to part 4. In that, my lords, 5. Each departmental committee should decide its own method and procedure for objective assessment of the suitability of the candidate. No interview should be held unless and until it has been specifically provided for in the recruitment rules for the post service. Whenever promotions are to be made by the method of selection by DPC and the administrative ministry desires that an interview should form part of the selection process, necessary provision should be made in the recruitment rules. Based on this, my lords, I contended that there is no specific provision. Their contention is that we are allowed to devise our own procedure. And as such, we held the interview and we conducted the selection process. According to me, my lord, is not correct in view of this, because this is the office memorandum. They say they relied upon in their counter, my lords, held before the learned single judge. Now, with regard to APAS, my lords, if lords take, my lord, the next page. Lords, I'll jump to, my lords, 6.1.3, minutes in that. It starts with, my lords, while merit has to be recognized and rewarded, advancement in an officer's career should not be regarded as a matter of course, but should not be earned by dint of hard work. Good conduct and result-oriented performance are as reflected in the annual confidential reports and based on strict and rigorous selection process. Government also desires to clear the misconception about average performance. While average may not be taken as an adverse remark in the respect of an officer, at the same time, it cannot be regarded as complimentary to the officer, as average performance should be regarded as routine and undistinguished. It is only performance that is above average and performance that is really noteworthy which should entitle an officer or to recognition suitable rewards in the matter of promotion. Confidential roles are basic inputs on the basis of which assessment is to be made by each DPC. The evaluation of CR should be fair, just and non-discriminatory. Then, my lords, the DPC should consider CRs of equal number of years in respect of all officers considered for promotion. The DPC should assess the suitability of the officers for promotion on the basis of their service record and with particular reference to the CRs for 5 preceding years. However, in cases where, my lord, it is not there, they say, my lords, the previous year should be considered. That is what, my lord, the DP, my lord, the procedure which is stipulated by the government, my lords, which they say we follow. That is not done, my lords. It can be seen that, my lords, 90 marks is obtained, my lords, for 2 years, and it comes to 78. Though earlier I was always above 90 and above.
We'll continue.
Please.
I thought I'll file a written synopsis and close it.
My lords, I'll also.
Day 8 or day.
No, I'll make, my lords, 2 to 3 page, my lords, shorter.
Both of us can.
Yeah, we best we can do it.
2 to 3 page only.
Lords, I'll start, my lords, I'll confine myself, my lords, as many.
4 to 5 pages for 3 working days, my lord. By Thursday, both of us can.
Please.
So it is over.
It will be treated as heard, my lord.
Can be.
Yes, we'll file the written synopsis by Thursday.
So that
Please.
nothing is left out.
Yes,
Please, my lords, I would.
Yes.
Serial number 81, Your Worship. Serial number 81, office objection may be overruled. I am not seeking any relief apart from the accused number 1.
Office objections are overruled.
Serial number 82, also 82 and 83.
Office objection is dispensed with. Yeah.
82 and 83 has applied to the entire order copy. Not only the other writ petitions, my lord, the caste title is not necessary, my lord. Serial number 82 and 83.
Office objection.
Office objection regarding the
So
full.
serial number 68 first time. So 4 week time is granted, 5 weeks time is granted. Failing which appeal stands dismissed automatically without
64 minutes.
reference to or order of the court. Same order in 69. And 70 is 70,
20.
71, 72.
Serial number 70.
In all, instead of 5 weeks, give 4 weeks and same order.
No.
Up to 73.
May I make a mention of serial number 70?
74, 75, 76. Oh, 10 times. 77
For the 10th time, they have not served a copy as well.
to 77, 2 weeks and failing which will be.
Serial number 64. 64 minutes. Minutes, I had to serve minutes on the counsels who appeared before the learned single judge, which I have served minutes, filed the acknowledgement also. It says minutes, it is not filed minutes, so your lords may.
Which one? 64.
64 minutes.
All.
In respect
Wherever
of-
the headline in all orders, wherever the office objections are removed, the official examine the same and place the.
Please.
Serial number 96 was listed today at 2:30 PM. The other side made a mention in the morning without informing us. It's a 2015 PIL, Your Lordship, and my seal deed is what is under challenge. And they have taken a date to March, from what we understand. Your Lordship, we pray for a shorter date and in the 2:30 PM list. It's a 2015 PIL, Your Lordship, and our seal deed is what is under challenge.
March is past. March will,
Serial number 70.
March past. Yes.
Serial number 70.
Why 80? Serial number 80. Without office objection, why A2 is made as a party in specific.
We have given time, you remove it.
Serial number 82, office objection complied, kindly be overruled, 82 and 83 also.
No.
Office objection are complied also, already complied also.